My lord. One civil division hearing, my lord. I am suffering, my lord. No injunction in Miss Appeal. I obtain injunction in the trial court, appellate court in Miss Appeal. My lord turned it out.
Negated.
Yes, my lord. Against that, my lord. It is very urgent, my lord. I am suffering. I have tried in the regular bench, but my lord, no accommodation. Hearing matter, my lord, for that reason.
There's no other side.
Yeah, other side, yes.
So,
Hearing matter. Other side is there. I will inform her.
First, you give the information. As in respect of mentioning, first of all, the opposite party has to be intimated.
I intimated her regarding.
There should be an endorsement.
Here, in sleep.
That it is being mentioned.
Or through one letter, I will communicate her.
শুনুন
দিন ওটা দিন তাহলে কালকে করব।
হ্যাঁ দিন ওনাকে দিয়ে দিন। So that later on no discrepancy arises.
Yeah, I will serve. ওটা একদিন দুপুরে দিয়ে দিন।
এবার ডাকুন ডাকুন। ডাকুন। ওয়ান কি হলো? রিটাইপ হচ্ছে তো ঠিক আছে, তো অর্ডার শিট রিটাইপে যাবে তো, ফাইলটা কেন? ফাইলটা দেবেন না, শুধু অর্ডার শিটটা দিয়ে দেবেন, ঠিক আছে? শুনুন, আগে আইটেম 1 কল করুন, আইটেম 1 কল করুন, তো বলে দিচ্ছি। আইটেম 1 আগে কল করুন।
Number 1, that I beg to appear for the applicant. Can hold.
ওই ফাইলটা তো এন্টায়ার তো নেই, একটু শুধু অর্ডার শিট, অর্ডার বুকটা গেছে, বাকিটা দিন। এটা অর্ডার
রাখতে পারেন। আই হ্যাভ এক্সট্রা কপি। আমি শরবতটা দিয়েছি। I have understood. Now you can proceed. My lord, that matter. Appellate. My lord, last occasion I failed to point it out one fact. This scan has been filed by that person who left out. Kindly take my cause title, my lord. Devoprasad Mondal is the applicant in Can 4. So that person, my lord, prays before this court to add him as a party appellant in connection with the appeal filed by, my lord, his other family members who are defendant as well as first appellant in the first appeal. Because in that second appeal, my lord, liberty was granted to that person. Accordingly, he filed left. Devoprasad Mondal filed that application to add him as a appellant. No, my lord, this is my submission. And my another submission is that, my lord, my lord, advocate on record is with me, my lord. My lord, Devoprasad executed the wakalatnama which is appended in the, my lord, application. He is the advocate.
You are representing both applicants and
No. I mean applicant. Appellant is represented by Arijit Bose.
কালকে তুমি অ্যাপিলেটের মামলা
My lord, subsequently I saw it, my lord, because my lord, we are on the same board, my lord. Kindly consider that aspect as well.
But I have not heard anything, but I have not seen anything.
Yes.
Yes, ma'am. I don't want to be personally in trouble, but I'll say nothing else.
My lord, another submission of mine is that if two appeals proceeded in different way, my lord, there could have been a chance of conflicting judgment. That is my HON'BLE submission. So if that person added as a appellant, no prejudice should be caused to the respondent, because both the persons who are appellant in connection with that appeal which is pending before your lordships, they also suffered a judgment and decree of the trial court as well as appellate court, and I also suffered, my lord, judgment and decree of trial court and appellate court. These are my submissions. Yes, of 17. And applicant in Can 4 also suffered by the same judgment, same decree, as well as suit court. In the trial court also, my lord, I lost. My lord, I am the party defendant.
All the appellants were.
In the defendant, my lord, I have annexed the decree of the trial court as well as appellate court. My lord, kindly take page 34 of the Can application.
আর কিছু বলবি না তো? This application, Millard, should be dismissed with cost. I just, Millard, indicate why. Kindly turn to Millard page 11 of his application. And everything, Millard, should have a limit. Page 11, paragraph 10. Oh, my lords. I'm grateful. My duty. Page 11, yes.
Murad, I am referring the applicant.
Mr. Bordon is representing the appellants as well. Yes, yes. He has made.
I'm referring the applicant out here. I'll tell you very frankly, Murad, there's a commonality of interest. Worship knows all the 5 were supposed to file the appeal. Inadvertently. No, Murad. Suit for declaration injunction. Murad, that a deed was executed was sham and void. Murad, it's a sale deed. Sale deed, Murad, executed by respondent one's predecessor. By Murad, the predecessor in interest of the Murad, the respondent number 1, in favor of the predecessor in interest of Murad. I beg to stand corrected, Murad, by the respondent number 1 in favor of the predecessor in interest of the applicant herein. So, Murad, there's a commonality of interest, Murad. All 5, the appellants as well as the applicant, wish to prefer the appeal. How inadvertently, Murad, the name of the Murad, the applicant, was missing from the area of parts in the cause title. So, Murad, that was discovered later on, Murad. We filed an appeal along with an application for condemnation of delay, Murad. In that appeal, in the application of condemnation of delay, Murad, there was an order passed on 25th of November 2025, which would appear at page 97 of my application, Murad, Can 4 of 2025. Murad, which sees this is an application of condemnation of delay that's taken up for consideration. Then, Murad, the objection raised by the learned counsel to the respondent number 1 to 10, such and such, is that the appeal is not maintainable in view of the provisions contained in Order 4120. Murad, I relied upon Order 41 Rule 20 to say that on defect being pointed by the court, on hearing the appeal, necessary steps can be taken up for addition of party. That would be at page 98, Murad. Then, Murad, the relevant portion would be page 98, Murad. The third paragraph, which starts with, upon hearing the learned advocates. And considering the facts of the case, this court is of the view that the appellant should be granted reasonable opportunity to make a necessary application in the pending appeal, which is being heard by the learned coordinate bench of this court. So, hence this application. The interest is common, Murad. So, was the other appellants in this matter is concerned, Murad, and the applicants, they sail on the same boat. That's why, my lord, that's the precise reason, my lord, why I have sought that I may be permitted to join the array of parties. Where, my lord, on the Order 41 Rule 20, I submitted on that court, my lord, that I could be added as a party. Even Order 1 Rule 10 grants me sufficient protection, my lord, or liberty, my lord, to prefer this application. So those are some substance of my application, my lord. No, my lord.
My lord has seen paragraph 10.
No, you were referring to
Paragraph 10 at page 11.
paragraph 10, yes.
Yes.
Constraint to prefer nothing, determining the propriety of the appointment of level and decree which is after with nothing. Earlier, the learned judge in the Court of Appeal, this below was pleased to dismiss without applicant conduct question which only registered was accompanied by an application seeking condemnation of delay according to the right of 1053. Yes,
Then, my lord, 11.
further reveal that the applicant can in connection with the financial city statement consideration and rather to serve in the learning application of public application definition care with interaction of the person technical consideration of the yes.
So, my lord, admitted position of fact this. My learned friend's client, my lord, today he is representing the applicant. While my lord, the appeal was being heard, my learned friend was representing the appellant. He says
Yes,
there
yes.
is.
Yes, yes, I was.
I don't need an approval. My lord, he was. And he says there, my lord, is a commonality of interest which is not there. My lord, that is at the right point of time, my lord, I'll disclose that. So, my lord, he filed an appeal, separate appeal, consciously. Took out an application for condonation of delay. Subject to correction, delay is yet to be condoned. My lord, the appeal is yet to be borne. But, my lord, that is on record. My lord, when the application was moved, my lord, he sought for a permission under Order 41, Rule 20. That's, my lord, his submission today also before your lordship. Now, kindly have a look at the provision of Order 41, Rule 20. Kindly, my lord, have a look at this. Kindly see the heading, my lord, of Order 41, Rule 20. To be made respondents. Order 41, Rule 20 does not give him a leverage, my lord, to take out an application for addition of an appellant. It's unheard of. My lord, on one ploy or the other, he is continuously, my lord, dragging this appeal, enjoying an interim order. So, my lord, Order 41, Rule 20 does not even contemplate, my lord, addition of an appellant. My lord, there is a reason why. My lord, if today Mr. X is added as an appellant, my lord, the appeal is born today, qua Mr. X. What about, my lord, then the delay in filing this appeal by Mr. X? For Mr. X, my lord, the appeal will not get, my lord, dated back to the date of filing of the appeal. That's, my lord, a rudimentary principle of law. And my learned friend clients know that. My lord, he is on forum shopping. Files an appeal, time-barred appeal. My lord was exposed to, my lord, get a thrashing, my lord, from the Honorable Court. Then says, I will take out an application under Order 41, Rule 20. That is, my lord, the impression created there. Annexed E, my lord will kindly have a look at Annexed E. page 97.
It has been gone through.
Learned advocate for the applicant disputes the submission, relies upon order 41 rule 20. Then Millard, kindly see. Upon hearing the learned advocates, considering the fact this court is of the view that the appellant should be granted a reasonable opportunity to make necessary application in the pending appeal, which is being heard by a learned coordinated bench of this court. So, Millard, the idea given, impression given was order 41 rule 20, and that is the submission made today also. Order 41 rule 20, Millard, does not even, Millard, postulate, Millard, addition of an appellant. And the reason is this, that Millard, if today the appellant is added, someone is added as the appellant, Millard, for that particular added party, the appeal would be born today. Then Millard, what? Everything would be in a mess. Again, Millard, a delay condonation, whether Millard that's permissible or not, everything is to be looked into then. And this gentleman, Millard, he is still pursuing. He has not withdrawn himself from that appeal. Millard, two parallel proceedings, Millard, simultaneously something which has been, Millard, strictly deprecated. I need not, Millard, show any decision on that. And my learned friend, Millard, has made a whisper on, Millard, order 1, rule 10. Kindly, Millard, have a look at order 1, rule 10, sub rule 1. Kindly, Millard, just have a look. When, Millard, someone can be added as a plaintiff, that is the principle which should be followed if my learned friend is asking, Millard, him to be joined as an appellant. That is the principle to be followed. It says, I'm sorry, Millard, when a suit is filed in the name of a wrong plaintiff, or there is a confusion who should be the proper plaintiff, then and then only the Honorable Court may have discretion, Millard, to add someone as a plaintiff. That's not his case, that the appeal has been filed in the name of a wrong appellant, or there is a confusion, Millard, who should be the appellant. That's not a case made out, Millard, in the body of this application. So, Millard, firstly, order 41, rule 20 stares at his face. It's as misconceived an application as it could be. And when this application comes up, when, Millard, the appeal was in the midst of being heard. So, Millard, this is completely a dilatory tactics. And shockingly, Millard, the applicant, Millard, pleading commonality of interest is being represented by the same set of lawyers. Secondly, Millard, there is an appeal pending from the same judgment and decree by this gentleman. He has not withdrawn himself from that. There he was exposed to a threat of getting his appeal dismissed. So, Millard, two parallel proceedings cannot, Millard, concurrently run. Third, Millard, if today he is added, Millard, the appeal would be in a mess because, Millard, this appeal, this appellant would be time-barred. Then, Millard, had to start de novo, Millard, whether this appeal, Millard, some of the appellants is maintainable, some of the appellant is not maintainable and all. There's something unheard of, which is why under order 41 rule 20, there is no scope, Millard, for adding someone as an appellant. That was the wisdom of the legislature. So, Millard, this application, Millard, in my most humble submission, Millard, should be shown the door, and, Millard, an exemplary cost must be, Millard, now imposed. Millard, we have been suffering, Millard, an interim order for long, despite, Millard, having succeeded in both the forums below, in both the courts below. This is, Millard, from a judgment on affirmation. These are, Millard, my humble submissions.
Let me respond. May respond. Well, the issues.
First of all, whether the
other appeal
the
is
second
pending or
appeal,
not.
SAT 153 of 2024.
It's pending or not. That's
Pending.
the query from the one. I'll answer that. But Millard, kindly takes page 97 for once. Kindly takes the order. Millard, let me make it very clear at the outset, Millard, that appeal was filed by the same applicant who's filing the application. There, my lord, we took out an application for condonation of delay in the appeal. My lord, when the application for condonation of delay was being heard, then my lord, this order was passed. Kindly takes, my lord, page 97, and my lord, kindly takes, my lord, the first, second, third, first, fifth paragraph. It is not me, my lord, who said that that was an application under Order 41 Rule 20, or the present application is one under Order 41 Rule 20. Kindly seize. The objection raised by the learned counsel for the respondents number 1 to 10, Mr. Ray, is that this appeal is not maintainable in view of the provisions contained in Order 41 Rule 20. So, my lord, a submission was made at the bar that that appeal was not maintainable because of Order 41 Rule 20. So what was sought to be impressed upon the honorable judge was that in view of Order 41 Rule 20, that appeal was not maintainable. When Order 41 Rule 20 makes it very clear that a party should be joined as a respondent. Then takes the next paragraph, I say, learned advocates for the appellant disputes the submissions relies upon order provisions contained in Order 41 Rule 20, so and so forth. Necessary steps can be taken of addition of party. In instant case, no such order was passed by a learned judge. So, my lord, when this appeal was pending here, there was no order for addition of party. And I said Order 41 Rule 20 could not have been resorted to in view of the fact that whoever applies under Order 41 Rule 20 would be made a respondent. Whoever applies under Order 41 Rule 20 would be made a respondent. Therefore, my lord, I was constrained to take out another appeal. Now, the honorable judge doesn't dispose of my application, but passes an order, my lord, kindly cease. I say that the learned advocate kindly sees page 98. There was further submission on my part saying that the party who has suffered a decree can maintain a separate appeal. This appeal is not barred by law and it can be heard upon condonation of delay. That was my submission, my lord. So Order 41 Rule 20 was not resorted to at my end, my lord. Then, my lord, upon hearing the learned advocates and considering the facts of the case, this court is of the view, my lord, so this is a view of the court. It's not something which I had sought liberty for, that the appellant should be granted a reasonable opportunity to make necessary application in the pending appeal which is being heard by the learned coordinate bench of this court. So, my lord, liberty was granted to me to make an application before this court. Now, my lord, from the appeal and the conduct and this order, what would emanate is very simple, that I, this applicant, wish to be added as an appellant. He does not want to be, my lord, relegated to the status of respondent. Therefore, we did not make any Order 41 Rule 20 application. So, my lord, here we come, after this order has been passed, my lord, we come and make an application for addition of party. We merely say Order 41 is this, and additionally, the court has a power to add as a party appellant in a particular appeal. So that's the provision of law. Then, my lord, kindly sees this matter is being kept pending. And I say this, my lord, because till the time the application for condonation of delay is allowed, my lord, a second appeal is not set down for hearing under Order 41 Rule 11, my lord. My lord knows it. So therefore, my lord, that appeal, if I put it this way, my lord, can only see the light of the day once my condonation application is allowed. And both the matters have been kept pending by the honorable judge. So, my lord, that the appeal is pending cannot be attributed, my lord, to any fault or laches on my part. That's my first contention. Number two, my lord, Order 1 Rule 10 was read out, my lord. Kindly now one takes the trouble of coming to Order 1 Rule 10(2). Order 1 Rule 10(1) says, name of the wrong party, doubtful, so and so forth. Now kindly takes Order 1 Rule 10(2). My lord knows an appeal is the condition of the suit. Kindly sees, my lord. The court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and the name of any person who would be joined whether as plaintiff or defendant or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit be added. Now, my lord, in an appeal, the connotation of the term plaintiff is an appellant, my lord. Defendant is a respondent. Suit is an appeal. So, my lord, Order 1, Rule 10(2) grants, my lord, any court ample power, my lord, at any stage of the proceedings to add any party as an appellant. This is not an application, my lord. Kindly seize my application in the matter of an application for addition of party, my lord. I have not said that this is an application under Order 41, Rule 20. I am very conscious of the fact what Order 41, Rule 20 mandates. In fact, this Order 41, Rule 20 issue was, my lord, urged by the learned advocate representing the response from 1 to 10 in that appeal. It was not a submission made at the bar from my side, my lord. Kindly seize, my lord, my paragraph 12. My lord, page 12, paragraph 13, my lord. My lord, the first 5 lines pertains to, my lord, Order 41, Rule 20. Thereafter, my lord, says, additionally, this court may at any time order that the name of any person who ought to have been joined and or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the list be added. This is the fulcrum of my argument, my lord. My lord knows this, my lord has seen this. There were 5 defendants, my lord. 5 of them, my lord, filed the first appeal. 5 of...
Except you.
No,
Second,
my lord.
first appeal.
Yes, my lord. My lord, they suffered reversal, my lord. So they come before the court and all of them, my lord, wanted to prefer this appeal. Inadvertently, the name of one of them, my lord, one of the parties, meaning thereby the applicant, was inadvertently left out, my lord.
Mr. Bardhan, this cannot be digested that inadvertently left out.
But this was inadvertent, my lord. My lord, facts are stranger than fiction.
Ultimately,
Left out.
he is not a appellant in this second appeal.
As of now, he is not an appellant. Now, my lord, may I put this? Initially, my lord, kindly sees, initially this matter was being conducted by one Mr. Priyabrata Bhattacharya, one Mr. Priyabrata Bhattacharya. My lord, I say this, my lord.
Mr. Bardhan need not go into the fact who was conducting. Mr. Banerjee.
It's very short reply.
Hmm?
Kindly,
No,
my lord.
Reply to reply.
No reply to reply.
My lord, in reply, my learned friend has argued something which, my lord,
He has argued.
neither my learned friend, not my learned friend argued at the, my lord, threshold. Once I have shown, my lord, Order 41, Rule 20, then, my lord, he grows wiser and, my lord, argues this. My lord, Order 1 heading, kindly see, my lord, that deals with parties to the suit. My lord, my learned friend is applying Order 1, Rule 10, my lord, substituting Order 41, Rule 20 in a chartered high court. Kindly see, my lord, Order 41, Rule 20, Sub Rule 2.
Mr.
Well,
Banerjee,
there should be a limit.
what do you want? Do you want to have the present second appeal adjudicated?
In his absence, this gentleman cannot poke his nose now. Cannot.
What is the question of poking my
My lord, he can be added at the very best as a respondent because Order 41, Rule 20, my lord, permits that. Kindly have a look at Order 41, Rule 20, Sub Rule 2. It says if this is time barred, my lord, this should be, my lord, thrown away. Kindly see, my lord, Sub Rule 2. And my learned friend is relying on Order 1, Rule 10. Drawing analogy of, my lord, plaintiff and appellant, same.
Mr. Bardhan is relying upon Order 1, Rule 10.
But does not apply here. Then, my lord, what would be the effect of Order 41, Rule 20, my lord, I wonder.
Now you are relying upon Order 41, Rule 20.
Sub Rule 2, kindly see.
Sees, my lord. No respondent can be added.
Thereafter,
Yes.
no respondent shall
Yes.
be added under this rule
Yes.
after the expiry of the period of limitation for appeal.
Correct.
Unless.
So, my lord, respondent, kindly, my lord, visualize the argument.
Mr. Banerjee,
He
Mr.
is-
Banerjee, there's comma.
Yes.
Unless.
Unless the court
Yes.
Yes.
for reasons to be recorded, allows that to be done on such terms as to cause as it thinks fit.
Correct. In case of respondent. Order 41, Rule 20 does not even open a door, for a person to be added as an appellant. Contradicting, Order 1, Rule 10. That's the difference between a suit and an appeal. My learned friend is suggesting inadvertence. Inadvertence would have occurred, had he filed, signed Wakalatnama, and his name had been left out while filing the appeal. He has not even approached, the court.
Yes.
And this is not permissible in law. Law will go for a toss. If he prays for being added as an appellant, then new provisions are to be imported in CPC.
Anything more,
No, Milord.
Mr. Bordon?
Well, nothing more, nothing beyond this. I would say it's an application of additional parties simpliciter, my lord, in an appeal. And I say, my lord, Order 1, Rule 10.
Does not apply here, Milord.
Obviously, but I would have said the same thing if I was there. Be that as it, my lord. So the point today is, my lord, Order 1, Rule 10, Sub Rule 2 grants the court the power, my lord, to add a party at any stage of the proceeding. It does not say suit, my lord. Kindly visualize this. Proceeding and not a suit, number one. Number two, most importantly, my lord, my learned junior friend tells me that, my lord, we would want to have an inspection of the records for the Wakalatnama is concerned, because a point has been raised by learned friend saying that his name was not, they did not sign the Wakalatnama.
That's not their case.
So kindly.
So I rely on their case.
That you can
I have not inspected the Wakalatnama.
Kindly permit me to have a look. If that is there, then that inadvertence.
You have it inspected during the course of the day.
I'll have it done. Because even otherwise, my lord, if that name is there, then all the problems get settled out.
No.
No, then what has been submitted at the first instance?
Inadvertence.
That's the question of inadvertence.
Then what has been submitted by Mr. Bordon at the first sight, that can be taken into consideration. But let us see.
But
Then Milord carries all the more a foul play. Milord, he files a Wakalatnama here, asks him to file an appeal and goes and file a separate appeal. All the more a foul play on the court. It's a fraud on court.
But Mr. Bordon, something more is to be done on the part of the applicant. If there is a signature of that person in the Wakalatnama,
I appreciate.
Then why the other appeal?
No, my lord, kindly.
that cannot be
I'll be
suggested.
very,
That cannot be suggested from
my
the
lord,
end.
my lord,
Yes.
my lord, if that is something which what my lord indicates,
First of all, first of all, go through the Wakalatnama filed. If you find that inadvertently means if there is a signature of that person,
In the
applicant in the Wakalatnama, then in that case,
Lord, I'm not sure. I'll just
Then-
check up and get back to you, my lord, on this.
then you will have to take further step.
Lord,
Not here.
I appreciate, I understand what's falling from my lord, but my lord will not put me to this onerous terms because I'll have to do something which my heart will not permit. I can't go against an advocate. I should not go against an advocate.
No. I'm not suggesting that one. Will both the appeals continue?
No, my lord.
That I am
If
suggesting.
this is allowed, my lord, I'll withdraw that. As long as my interests are protected, my lord, in fact, my lord, I was constrained to go there because of observations and my lord, submissions made at the bar during the pendency of this appeal. My lord, I'll definitely take and come back.
ওনাদের দিয়ে দেবেন আজকে during the course of the day.
Surely দেখে নে।
During the course of the day, go
I'll
through the
definitely-
Wakalatnama.
I'll definitely do it.
And
But the
that should
hearing
be
is
apprised-
concluded, Milord, of this application. Grateful.
that should be apprised tomorrow.
Yes. Keeps it, we mentioned, I'll apprise it tomorrow.
Okay.
Should I, Milord, put a short note, Milord, annexing decisions? These
Yes.
are so fundamental,
You
Milord.
can. If
Wait.
you are suggesting decisions, then you will have to refer.
Yes,
and,
Milord,
we-
we'll exchange amongst us.
Yes, Mr. Bordon will have to
Very
confer.
interesting question has arisen, Milord, Order 1, Rule 10 in an appeal.
Exact purely question of law.
Very interesting question of law, possibly for the first time has arisen here. Milord, I will. May have a week's time.
May or may not be.
Yes, because well, I say, because the word uses proceedings, not suit.
Let us
In order 1, rule 10 2.
Yes, 10-1 says suit, 10-2 says
Let
proceedings.
us taste this. May have a week's time. To put in
Yes,
our
yes. Then in that case,
Well, I'll take
when?
inspection. I'll take inspection of the course of the day.
During the course of the day.
video inspection.
Well,
Uh,
I guess the problem is solved.
Huh?
I guess the problem is solved.
no.
It's there. The signature is there.
Oh, all the more good for me.
So, Mr. Banerjee,
It's there.
Now, Millard,
It's there.
it's
there.
all the more better for me.
Fine.
Very good.
Well, we'll canvas this as we approach the culvert.
Very good.
So, when can it be kept? Monday.
Monday keeps it from. Keeps it on Monday. We'll submit written notes only.
Tuesday. Millard, my land.
Tuesday.
Then, Tuesday, Wednesday, I'm not here. Keeps it next Thursday.
Then Monday.
And Monday, Tuesday, Wednesday, 3 days.
Kindly stop Mr. Bordhan from minting money, Kindly stop him.
That cannot be. That injunction cannot be.
Who says? Mr. Banerjee says that.
So, on Thursday, the Thursday week.
Thursday week, keeps it on
Very
20th, subject
Thursday.
convenience.
Ready. Grateful.
20th then.
যার গাড়ির পেট্রোলের খরচা এত তা সে আবার অন্য লোক করছে আই এম সো গ্রেটফুল মিনিট
Can 4 of can 4 of 2025 na? Can 4 of 2025 is taken up for hearing. Full stop. Heard the learned counsel representing the applicant and the learned counsels representing the respondents in full. Full stop.
The appellant
At
is
this
not
stage.
represented today before you.
No, applicant.
Appellant is not here.
No, appellant is there. The
আজকে তুমি একা
the advocate,
prejudice well
the
taken
learned advocate on record is there.
point of prejudice well taken
For the day, there is a divorce, Millard, between the counsel and the lawyer. Advocate on the. ये दुष्टुमी है।
So the main person has not been heard. Learned counsel representing the appellant. What do you have to say?
তুমি চুপ করে থাকো,
obvious
বলতে দাও।
obvious
If the applicant is added as a party.
party appellant
আরে,
that's my application
who is hijacking whom?
there's no question of hijack bullet I said commonality that was my first submission bullet
কি হয়েছে? আবার পড়ুন। Heard the learned counsel representing the applicant, and the learned counsels representing two sets
Yes.
respondents. Learned counsels. Anything more to be added to Mr. Banerjee?
I'm listening
Heard the learned counsels representing the respondents and the learned counsel representing the appellants. Full stop. In full. Paragraph. At this stage, the learned counsels submit that they would wish to have authorities furnished in support of their contention. Full stop. On consent of both the sides, on consent of all the sides, let the matter appear on 20th of August.
I'm so grateful bullet
Written notes and if anybody wishes, written notes and citations.
I'm grateful
Citations to be exchanged prior to that.
that will do grateful
পরে দেখে নেবো বুঝেছো এটা পরে পাঠিয়ে দেবেন দেখে নেবো নেক্সট
item number 2
My lord, appearing for the respondent,
But I appear for the appellant.
but praying for not today, not this week actually, my
Yesterday,
lord.
my lord was angry. I was not present, my lord. I have come ready, my lord. May I start?
Yes, let us know.
My lord, one more submission. His maternal uncle has died yesterday.
Whose?
Dev Kumar Sharma. The advocate appearing for the respondent.
Well, I cannot complete it. Let him take notes, my lord.
Who is the advocate on record?
Dev Kumar Sharma,
His maternal uncle.
his own. Yesterday, that is the reason yesterday also didn't appear. Couldn't appear.
You are representing him? Take note of
I'll
his
take the
submission.
notes.
Take
and
note of his
he'll
submission.
submit.
May I, before beginning, my lord, may I once, my lord, check one document from the lower court record?
Trial court record.
Yes.
কোথায় গেল?
Let me exhibit 2 টা বার করো।
ওখানে কোথায় গেল? ওখানে ওনাকে ট্রায়াল কোর্ট রেকর্ডটা দিন তো, ট্রায়াল কোর্টের রেকর্ড।
LCR.
পিয়ন কোথায়? পিয়ন বাইরে কি করতে গেছে? হিয়ারিং এর সময় থাকতে বলবেন। ওনাকে ট্রায়াল কোর্ট পেপার বুকটা আমার দিন, আর ওনাকে ট্রায়াল কোর্টের রেকর্ডটা দিন।
Exhibit 2 টা একটু করো। And I am the plaintiff appellant. My lord, this is a judgment of reversal. Kindly see, my lord, the order dated, my lord, 2nd May 2022. What was the substantial question of law framed? 2nd May.
Two substantial questions of law were framed.
Yes, yes, yes.
There is a learned judge in the lower appellate court substantially erred in law and not considering the exhibit. Exhibit 2 is?
Exhibit 2 is the khajna. That is what, my lord, I was checking, my lord. Found?
Where's the learned counsel gone?
To bring, my lord, a
Achha.
white page for noting. Sorry, my lord.
You require a page?
Yeah.
You require a page?
No, I have it, my lord. I got it.
Something has fallen down. Which shows that the property. Be seated, be seated, kindly be seated. Shows that the property in learned judge. So reversal.
Yes, sir.
So whether it will come under the Transfer of Property Act or West Bengal Premises Tenancy
Yes,
Act.
my lord, the appeal court's judgment, lordship will be, my lord, astonished, my lord, the appeal court is, my lord, making this kind of observation, even after, my lord, admission in TW1. Even after, lordship will be astonished to find, and as I proceed. Ma'am, may I play? Kindly see the, from page number 1. Sticker. Oh, sticker. ওটা দিয়ে দিন 2 লাখ। My lord, may I place the trial court judgment for plaintiff file states that he is the owner of the rented property in which the defendant the premises tenant of one room at the rate of 200 per month payable by English calendar. Defendant is a habitual defender and has not paid any rent since August 1991. Several requests were made, but he did not pay any heed. Defendant has damaged the suit premises, changing the nature and character of the suit property, violating clauses MOP of section 108 of the TP Act. The plaintiff requires the suit premises for his own use and occupation. The plaintiff runs medical shop and he requires the room for go down to keep fridge and cooler and other machines to make the room good and for storage, and he to rebuild, and hence the defendant has to be evicted from the old structure. Old structure. On 23rd August 1999, he sent an eviction notice with AD card with the certificate of posting. The letter was required to be rectified. Another letter of rectification dated 5th October 2019 by registered post was sent. The defendant received the same, but he did not comply with the order. Then Miller cause of action. When Miller the prayers are set out, then Miller kindly comes to the next paragraph. Written statement was filed by defendant such and such. Defendant states that the suit is not maintainable and there is no cause of action. So the suit is is that for non-joinder and misjoinder. The cause of action, the court fees paid to be sufficient. The defendant denied plaintiff is the owner of the landed property and that he was inducted by the plaintiff as tenant. Defendant admits
Who was the inducting landlord?
inducted myself.
Yes, sir. Defendant admits.
Defendant admits he is a tenant in one shop room, but he was inducted by Motiar Rahman midday at the rate of rupees 140 per month. Thereafter, the shop room was transferred to Kasem Khan and the defendants used to pay rent to Kasem Khan. Defendant denied that he was a defaulter as he has paid filed separate petition under section 17(2) of the West Bengal Premises Tenancy Act. Lord, I will be also arguing on this point also. Defendant denies that he has damaged the premises under clauses MOP of section 108 of 8 and he is liable to be evicted as per paragraph 4. Paragraph 4, defendant denies that the defendant requires the room for his own use and occupation to store medicine as go down. It is also denied that he requires one room to make new structure. Defendant denies the eviction notice dated 23rd August 1999 and 5th October 1999. The plaintiff is required to prove the same. Hence, it is prayed that the suit is dismissed accordingly. Milord, apart from other Milord grounds, other issues, kindly see the issue number 2 is the suit governed by the transfer of property. Milord, this is what my lord has to Milord here, and that is the substantial question of law. And here now Milord kindly takes up Milord on the latter part of the page what were the documents marked. Exhibit 1 is a certified copy of the deed, that is my purchase deed plaintiffs. Then exhibit 2 LR Khotian number 735 and Khajna receipt, which shows Milord the property is situated in an area which is Panchayat area outside the Milord jurisdiction of a municipality or municipal corporation. Then Milord notice. Then Milord from the defendant side, Milord kindly see the court challan, then will of the fathers, then Shalishinama. Kindly see marked Milord Shalishinama. Exhibit C Milord Shalishinama. Milord, this will be also Milord relevant. Death certificate of death certificate such and such. Milord, why this Shalishinama? Because this Shalishinama was before the Panchayat Pradhan regarding the tenancy. And that is an admitted case. From the defendant side. After going through the plaint, written statement, materials on record, and testimony of the witness, the learned counsels made their respective submission. As per the plaintiff counsel, he states that the suit is for eviction of the defendant under Section 106 of the Transfer of Property Act. As in cross-examination, DW1 on the 3rd August 2016, in the first line, the defendant admits the shop room is in Panchayat area. The defendant that the transfer of property of provisions only require the service of notice. The title has been proved, and the notice and its service has also been proved. That the awardment of awardment of default reasonable requirement was as abundant precaution, though Transfer of Property Act does not require the same. That all challans have been marked as exhibit, that since August 1991 that any rent was paid was not forthcoming from the side from the part of the defendants. The suit is of 2000, hence the plaintiff prays for arrears of rent from 91 to 2000. The will has been mentioned by the defendant has not been probated. That in cross-examination on 1st July 2016, the change in nature of business has been admitted. The defendant is also not aware of the requirement of the plaintiff. Hence, the suit succeeds in all as all ingredients as per provision has been proved. As per the defendant counsel, he states that the predecessor was tenant of the suit property. The rent was enhanced. The rent has been paid throughout. The petition under, this is not 7(1) Miller, this is 17(156) has been paid. Challans have been filed. The defendant is defaulter since 1991 and is denied and false.
Notices of 23rd August 1999.
Yes. That no counterfall has been filed to show default since August 1991. There is no default. As there is no default, eviction suit fails. That the damage, as stated by the plaintiff, is denied, and also as no documents were filed to show that the previous condition to relate the present condition, that no commissioner report was held to any new structure. Hence, MOP is not tenable. And the learned trial judge also did not decree. We could not prove. There was no also cross objection. He could not also be MOP was also could not. We could not prove it also. There is no material in our hand also to prove any MOP. That
in local inspection commission took
no,
place?
not held. That was that the existing accommodation was not shown by objective standards as approved by court. That the plaintiff enjoys excess accommodation. The requirement is vague. That two notice of determination of tenancy varies in the plaint notice. That no registration of notice of or AD card was filed. Allegations of plaint to be corroborated by evidence by Section 101 to 104 of the Evidence Act. There is variance in pleading and in proof. That the defendant is that the defendant is earning from the shop since 60 years. That the plaintiff's suit fails on 3 grounds. On grounds default, MOP, notice, all. After going through the plaint, written statement, submission of counsel, testimony of the witness, and the documents on record on the issues to be determined are taken up individually. Then issue number 1 is maintainable. It was held maintainable. Then Millard kindly see the issue number 2, whether Transfer of Property Act or Premises Tenancy Act. Now, the cause title reveals the position of the suit property. Further, defendant number 1 in her cross-examination admitted in the suit property is in the Panchayat area. The exhibit 2 of the plaintiff confirms the act that governs the suit property. The defendant has made no such averment to the contrary, which establishes the suit that the suit is governed by Transfer of Property Act. Now, then Millard issue number 3, whether the notice of ejectment was served upon the defendant and whether it is a valid notice. The notice was served on 23rd August 1999 to the predecessor of the present defendant who has since deceased on 20th July 2012 as per Exhibit D dated 31st July 2012. Substitution was made on 25th July 2012. That as and when the defendants were substituted, they stepped into the shoes of the previous defendant, taking into the liability. Hence, the service of notice is deemed to be valid on the present defendant. Thus, when the notice as per Exhibit 3 was exhibited, no objection was raised. Thus, thus notice was served as valid. Now, Milord, kindly, Milord, this will be my alternative case. Kindly, Milord, marks the 3 dates given in this paragraph. Notice was served on 23rd August 2019 to whom? Predecessor interest of the defendant. Who was the original tenant? Who was since deceased on 20th July 2012. As per Exhibit D, that is the death certificate on 31st July 2012. Correct? Therefore, and the substitution was made on 25th July. 20th July, Milord, dead, and Milord substitution made on 25th July. Kindly, Milord, these dates will be, because once they say that this is Milord Premises Tenancy Act, Milord, the other provision will apply. Now, therefore, the issue number 3 goes in favor of the plaintiff. Then, Milord, issue number 4, plaintiff has stated the cause of action. Cause of action, Milord, was bundle of facts. Milord, ultimately, Milord, issue number 4 was also, Milord, decided in favor of the plaintiff. Then, Milord, kindly comes to issue number 5. Issue number 5, Milord, kindly see. The plaintiff purchased the property in 1991. No atonement of letter was sent. However, due to admission of the defendant on 3rd August 2016 under acceptance of the plaintiff status of the the relationship is admitted that though the defendant states that she had paid rent to the previous tenant no rent receipt was filed, but the valid service of notice, the criteria required for an eviction under Section 106 is fulfilled. You know, that is the only criteria in 106. The prayer of mean profit is not tenable. It was not given to me. The next paragraph, that the plaintiff did not cross-examine the defendant specifically in whose name the rent was deposited, and then being made in the court, the rent so deposited in court is attributed to this plaintiff. Then, last paragraph, in conclusion, it is seen the relationship of the landlord and tenant is established. Suit is governed by 106 TP Act. Valid notice was served. Hence, the suit succeeds and the eviction, and that is for eviction, barring the prayer for mean profit and costs, and eviction degree was passed. Now, Milord, kindly comes to the appeal court's judgment. Most surprising, Milord, judgment, Milord. It starts from page 9. Facts, Milord, I have already placed. My Lord would kind enough to come to page 16, decision with reason. The only ground of reversal, Milord, since the order under 17.2 was not challenged, then it come under the Premises Tenancy Act. If the Milord, if the order is otherwise, Milord, beyond jurisdiction, Milord, jurisdiction may be of 3 times: pecuniary, territorial, and lack of jurisdiction. Milord, this is, Milord, even if it is allowed and not challenged, Milord, it is lack of jurisdiction, nullity. I need not, Milord, challenge it at all. It is nullity for all purposes. Well, those would be my supplemental argument. I will be first, Milord, showing, Milord, their admission. They admit that it is a panchayat area. Now, Milord, kindly see, Milord, page 16, the moot question which has been raised by the learned advocate for the appellant, whether the learned trial court are correctly observed that the defendant appellant is not a premises tenant and he is a tenant under the Transfer of Property Act. Here I find that the plaintiff has filed a suit for eviction against Mohammad Khalil Qureshi, the predecessor of the present defendant's appellant, as a premises tenant under the West Bengal Premises Tenancy Act, and accordingly he issued notice of eviction treating him as a premises under the West Bengal Premises Tenancy Act on the ground of default in payment of monthly rent and also reasonable requirement and also on the ground of MOP. After receiving the summons, the defendant Khalil, the predecessor of the interest, entered appearance and filed 17(2)(2)(a) of the Premises Tenancy Act, and the application was disposed of by this court on 21st February 2008 by order number 102, wherein the learned trial court was pleased to hold defendants are premises tenant under the plaintiff in respect of the suit property, wherein and that order was not challenged by any of the parties before the higher forum. Therefore, the order passed by the learned trial court on 21st February 2008 is still in force. Moreover, the record reveals that the plaintiff, to prove the ground of reasonable requirement, filed an application under order 39 rule 7 for inspection to show the plaintiff required the tenanted premises for his own use and occupation, and that the petition rejected by the court on the ground that has been filed belated stage. Now the question is whether the court will come to the findings that the defendant is not a premises tenant under Premises Tenancy Act, but he is a tenant under the TP Act. On scrutiny of the judgment, I find the learned trial court relied upon the evidence DW1, who in her cross-examination has stated that the suit property is in Panchayat area, and the exhibit 2 of the plaintiff also confirms the act that governs the suit property. I am very much astonished how court will rely upon the document that is exhibit 2 and the oral testimony of DW1 when it was held by the learned trial court previously in a proceeding under 17(2) of the West Bengal Premises Tenancy Act that the defendants are premises tenant under the plaintiff, and that order that order was not challenged by the parties and not set aside by the appellate court. In the it is pertinent to mention, my lord, this is where, my lord, he has gone wrong. My lord, let us assume that the 17(2)(a) was filed and it was correctly decided. My lord, it is no longer res integra that the order passed in a 7(2) of application or a 17(2) of the old act. It is a tentative finding. That is not a final finding. That is only a tentative finding. Why tentative? Because there are line of judgment which say if the defendants are not allowed to deposit the arrears of rent and the current rent month by month, there is a clause under 17(3) or the current act, the 7(3), his defense will be struck off. For that purpose, prima facie, you have to determine landlord-tenant relationship. But that is a prima facie and tentative finding. In every eviction suit, my lord has experience. My lord, the issue has to be framed and decided at the final trial.
So according to you, though nothing has been preferred against the 17(2) application, that has been passed having lack of jurisdiction. That's why
Need not be challenged at all.
Need not be
There is a my lord, difference between orders, my lord, where, my lord, erroneous and orders which are nullity. Order, my lord, are erroneous are those, my lord, which
require challenge.
Which require a challenge and passed by a court of competent jurisdiction.
Herein, according to you,
a court of competent jurisdiction passed it, but it was nullity because the suit was under 106 of the TP Act. Alternatively, let us proceed on the basis my lord is not satisfied in this with this, my lord, submission. Then, my lord, 107 of the, my lord, Civil Procedure Code is the answer. If, my lord, in interlocutory order affecting the merits of the suit is not challenged and the, my lord, provision of appeal or revision is there, that has not been done, that can be challenged, my lord, in the appeal itself from the final degree. Therefore, even if, my lord is not satisfied with my earlier part of the argument, I can even challenge, my lord, the 17(2) in this, my lord, second appeal before your lordship.
Yes. In 1956 Premises Tenancy Act, 1956 এটা যেমন 1997 এটা 56 এর একটা পেয়ার তাহলে আনাতে হবে বুঝেছেন 1956 ওয়েস্ট বেঙ্গল কনস্টিটিউয়েন্সি অ্যাক্ট 1956
Milord, yes. Kindly see Milord section 105. Or let me finish the judgment, then come.
yes. Whichever you feel better
Because since I raised Milord,
I think it should be taken up now. Yes.
save to kindly see 105. Save as otherwise expressly provided, no appeal from any order made by a court in the exercise of its original or appellate jurisdiction, but where a decree is appealed from. This is a decree which was appealed from any error, defect, or irregularity in any order. Any order includes an interlocutory order affecting the decision of the case may be set forth as a ground of objection in the memorandum of appeal. Therefore, I can take this as an ground in the appeal, and I can argue and I can challenge it. But even if your lordship does not, Milord.
But Mr. Maharajaji, one thing has to be kept in mind that you had not preferred the first appeal. The first appeal had been preferred by your adversary.
But it does not, Milord, refer to any only first appeal or second appeal. I can here set forth as a ground in the second appeal. This is my appeal.
No,
Because
putting against you.
Exactly. Because I did not have, because the suit was, Milord, filed, was decreed in my favor. I did not have a chance to prefer an appeal. Trial court decreed the suit in my favor. This appeal, Milord, it does not restrict it only to a first appeal. Kindly see. And Milord, subsection 2 is not required because it is for a case of remand. This is Milord, not a case of remand.
Herein there was no question of remand.
There was no remand. Milord, simplicity is set aside. Only this ground. This is the only ground. Then Milord, second paragraph, kindly see. It is pertinent to mention that the plaintiff from beginning on the date of filing of the suit and prior to filing of the suit treated the defendants as premises tenant under the West Bengal Premises Tenancy Act, and he served 1 month notice for the eviction of the defendant from the tenanted premises, knowing fully well that the defendants are the premises under section West Bengal Premises Tenancy Act. Now, Milord, let us, Milord, proceed that the notice is wrong. Milord, kindly see the Transfer of Property Act. Milord, the learned trial judge, Milord, appellate court, Milord, with deepest of respect, Milord, has thought that, Milord, the tenants under the, Milord, other than, Milord, municipal area, they are not premises tenants. Milord, this is his, Milord, appreciation of law. May I kindly see, Milord, section 106.
Yes.
Kindly see. In absence of a contract or local law or usage to the contrary, a lease of immovable property for agriculture or manufacturing purposes shall be deemed to be a lease from year to year, terminable on the part of either of the lessor or lessee by 6 months notice, and a lease from immovable property. Malad, this is where I fall. Immovable property for any purpose any other purpose shall be deemed to be a lease for from month to month, terminable on the part of the either of the lessor or lessee by 15 days notice. This, Milord, he says, I have given them a 30 days notice. What is the minimum requirement? Is you cannot give a notice below 15 days. You have to give a Milord notice 15 days or above. Milord, cutoff point is 15 days.
Minimum 15 days.
Minimum 15 days. I have, Milord, either on misconception or something else.
30 days.
30 days. But therefore, this does not make my notice bad. If I have given a notice, you vacate the premises on the end of 13th day or 14th day. Yes, that is a bad note. That is a bad notice because law says minimum 15 days.
Sufficient time was not provided to them.
Exactly so. sufficient time was provided, another 15 days was provided also, my lord, total 30 days. Because therefore, this, my lord, finding of the learned appellate court that my notice is bad, only because I have given quoted 30 days, it will fall within the Premises Tenancy Act. My lord, subject to correction, this is not a correct finding.
Prior to moving from the notice point, let the notice be placed.
Very good.
এই কি বলে এক্সিবিটটা টু দেবেন এক্সিবিট
I have put up, yes.
প্লেন্টিফেড মানে 1 2 3 4 যেটা আছে না সেই এক্সিবিটটা ট্রায়াল কোর্টের রেকর্ডে ও আচ্ছা ঠিক আছে you can place from there also, you can place from there also.
Lord, the heading is notice of eviction of tenancy. This is 23rd August. Under instruction from and on behalf of my client Sri Shujit Kumar Paul, son of such and such, residing at Kailisi village, Mirgola, POPS such and such, district such and such. I do hereby write to you as follows. Yes. That you are a monthly premises tenant under my aforesaid client in respect of one Pakka shop room comprised in Dag number 511, Khotiar number 735 of Mouja Makura, jail number 55 within PS Jomjur, district Howrah, at a monthly rent of 200 payable according to the English calendar month, and the month of your tenancy is from first day and to last day of either of every calendar month. Therefore, my lord, 106.1, my lord, this is the first part. Kindly see, my lord, again 106.1. Kindly see, in absence of a contract or local law or uses to the contrary, the lease of immovable property or agriculture or manufacturing purposes shall be deemed to be a lease from year to year. We do not fall under this category. Terminable on the part of either lessor or lessee by 6 months notice. I do not fall under this category. A lease of immovable property for any other purpose, whether this is residential purpose, any other purpose, shall be deemed to be a lease from month to month. Therefore, this is month-to-month tenancy, terminable on the part of either of the lessor or lessee by 15 days notice. Therefore, 106.1, my lord, I fulfill. Now, my lord, if the appellate court is of the opinion that since he is a premises tenant, he will fall under the Premises Tenancy Act, my lord, I cannot. Lordship has to, my lord.
No, replace the entire notice.
Yes. Then, my lord, paragraph 2. That you are a habitual defaulter in payment of rent and default on the from month of August 1991 till today. My lord, the learned appellate court again thought, my lord, since I have said that you are a defaulter, then section 6 of the Premises Tenancy Act, 7 of the Premises Tenancy Act will apply. Then, my lord, again 3, that aforesaid client time and again requested you to pay rent, but you have failed and neglected to pay and the monthly rent to my client. Moreover, you are causing damage to the said room and are liable to be evicted. Damage, my lord, MOP we could not prove. The said room is reasonably required by the said client for his own use and occupation. My lord, again reasonable requirement. The appellate court thought again it's a Premises Tenancy Act. And also for building.
All the grounds were kept into contention. Reasonable requirement, MOP, default.
These are also ground under the TP Act also.
No.
Yes. Therefore, I, under authorized client, do hereby give you notice in writing, requiring you to quit, vacate, and deliver and cast possession of the client of the suit property which is in your occupation with the expiry of the month of September 1999. This was, my lord, on August. He gives, my lord, end of September, my lord, more than 1 month's notice. That is what is recorded. And all relationship of the landlord and tenant, that is the said client, you shall be absolutely ceased on and from 1st of October 2009, failing which my client shall be entitled to institute appropriate suit or legal proceeding for eviction for your wrongful occupation till recovery of past possession, holding you liable for means profit and damages. My lord, this was the done. And the most important is the address.
Hmm.
Address of the defendant, because where it was Millard served. Address is
So throughout the entire notice under the West Bengal Premises Tenancy Act has not been mentioned.
now Millard kindly see the address. Address of the
In
defendant.
the last portion also not mentioned.
No. 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 Kindly see to Muhammad Khalil Qureshi, son of not known, care of some meat shop, village and PO Bankada Jhilpada PS Domju, village and PO. And this notice was served, ID card was there, and on that Millard finding, it was it was both the courts accepted that the notice was served. Notice
No,
was served in village.
There is no denial on their part that it was
There
not
is
served.
denial, but court did not.
Did not accept neither the trial court nor the first appellate court.
Also, schedule is mentioned in the letter. All that piece and parcel of one pakka room on the ground floor comprised of dag number 511 under Khotiar number 735, Mouja Bankada, jail number 35 under PS Domju, this district Howrah, same address. And it was Millard delivered. This was delivered. And the ID card is also there, Millard. Yes, it's village and PO. এইটা এইটা আর ওইটা
ঠিক আছে লাগবে না।
আচ্ছা তাহলে এখানটা রাখুন, আমি আবার অর্ডারের ফাইলটা রেখে then Millard kindly see Millard the therefore 1 month notice Millard, I suppose Millard I have tried Millard satisfied your lordship, minimum 15 days, you cannot go give below 15 days. Here Millard 30 days notice was given. Here I find from the LCR and from the filing of the application under section 117(2)(2)(a of the West Bengal Premises Tenancy Act. Kindly use 1 minute. It is here I find from the LCR that after filing of the application under 17(2)(a of the West Bengal Premises Tenancy Act, the predecessor of the present defendant Muhammad Khalil Qureshi adduced evidence as PW1 in the proceeding under 17(2)(2)(a and produced the examination in chief. He admitted that the plaintiff in his he admitted that the plaintiff is his landlord and the plaintiff did not adduce any evidence in his proceeding under section 17(2)(a of the West Bengal Premises Tenancy Act, and the learned court after hearing of argument of both the parties was pleased to hold that the defendants are premises tenant under the plaintiff in respect of the suit property at a monthly rent of ₹65 payable according to English calendar month, by order number 102 of 21st February 2008. The question which has been raised by the learned advocate for the appellant that the order passed under the proceedings under 17(2)(2)(a of the West Bengal Premises Tenancy Act regarding relationship of landlord and tenant had already been decided finally by the learned trial court. Now the learned trial court cannot observe that the appellants are tenant under the plaintiff as per the provision of Transfer of Property Act and not Premises Tenancy Act, and he cited a reported decision reported such and such and further submitted that once it is decided by the learned trial court that the defendants are premises tenant under the Premises Tenancy Act, Millard, this is completely erroneous finding. Where did Millard, the learned trial court in the Millard judgment, Millard said so? May I ask myself? The learned trial court specifically held to be at Millard Transfer of Property Act. Kindly Millard again sees the judgment. The last issue. Millard kindly see page 7, last paragraph of issue number 5. Completely wrong finding. Millard, what issue, he has given at the 17 stage does not matter at the final hearing stage. Because kindly appreciates one thing. Today, a suit is filed. Now, kindly, yes, the learned trial judge and tenant, premises tenant under the Premises Tenancy Act, the court cannot hold that the defendants are not premises tenant, but they are tenant under the West Bengal Premises Tenancy Act under the plaintiff. The Here I find that the plaintiff all along treated the defendant as a tenant under the West Bengal Premises Tenancy Act. Nowhere the plaintiff has stated that defendants are tenants under the Transfer of Property Act. When it was finally decided under 17(2) of the West Bengal Premises Tenancy Act, the defendants are premises tenant, and all where the tenants are there, residential tenants are all premises tenants, be it premises tenancy or be it Transfer of Property Act. These finding and the order not set aside by any court of law, the trial court cannot change or alter the said order sitting in the same chair. The learned trial court relied upon the ROR and the rent receipt in Exhibit 2 and 2.1, and the RSROR cannot be relied upon as a document of presumption that the plaintiff is a tenant under the Transfer of Property Act. Who says that? Who says? It is relied upon for the purpose where is the property located. The relationship between the lessor or lessee or the landlord and tenant will be determined by the production of rent receipts. Who says? But this is, he proceeds that the plaintiff is a tenant under the Transfer of Property Act and not a Premises Tenancy Act. Who has relied upon, for what purpose it was relied upon? It was relied upon to show where is the property located. The existence of a landlord-tenant relationship can be ascertained from the rent receipts. But again, a wrong finding. The plaintiff was very much aware that where the suit property is within the municipal area of the Panchayat area, and knowing fully well that the suit property is situated within the municipal area, the defendants are premises tenants under the West Bengal Premises Tenancy Act. So the plaintiff filed the case for eviction and the defendants as per the West Bengal Premises Tenancy Act.
This line, and knowing fully well that the suit property is situated within the municipal area. Is it so?
Lord, I could not find, because LR Khotian and the Khajina receipt of the Panchayat is given. Exhibit 2 series, 2 and 2.1.
Yes, ma'am.
Then will not kindly see the it is settled principle of law that who he files the case as the plaintiff is to prove his case, and the plaintiff adduced evidence in his evidence, and he categorically stated that the defendants are premises tenant under him. So he can say that the defendants are not a premises tenant, but is a tenant under the Transfer of Property Act, only on the basis of evidence of DW1 Rashida Begum, who on orthodox illiterate Pardhanashin lady, the plaintiff must have established his own case, and the plaintiff should not depend upon the evidence of the defendant.
Who is DW1? Wife of Khalil Qureshi.
Let me check. I, Reshuda Begum, daughter of late Muhammad Khalil Qureshi.
Daughter of. Apart from DW1, anyone deposed?
No.
On the death of Khalil Qureshi,
On the death,
who is in possession?
on the death of Milord, on the death of Khalil Qureshi, Milord, Jalal Qureshi, Jamal Qureshi, they are the sons. Rashida Khatun and Shahida Khatun, they are the daughters.
Oh, so all the daughters,
They are the daughters.
the wife and the daughters.
No,
No,
wife is
wife
not there.
is not there.
Two sons, two daughters.
Two sons and two daughters. Acha. So the sons did not depose.
Son is not deposed. This time to দেখতে পেলাম না। না এখানেই আছে।
The sons were major.
That is, Milord, very difficult, Milord, for me to answer. Milord, kindly see, Milord, page 15 of the paper book. Milord, at the middle, on the other hand, the defendant has examined Rashida Begum as DW1 and
DW1,
only one.
only DW.
Here I find that the plaintiffs all along treated the defendants as premises tenant, and it is palpably clear from the notice of eviction that the other documents and the documents of the defendant's predecessor Muhammad Khalil Qureshi was a premises tenant, and this, Milord, ultimately, Milord, the same finding, Milord, 17(2)(a) was not challenged, hence, Milord, premises tenant, and that suit judgment was reversed. Milord, this is the only finding. Paragraph 20, Milord, kindly see. Again, the third paragraph here in this case, I find that the learned trial court in the time of disposal of the application under 17(2)(a) was pleased to hold the defendants a premises tenant and under the premise in respect of the suit property not challenged by the parties before any higher forum. Therefore, the order has finality and cannot re-agitate the same, and this is, Milord. Hence, Milord, kindly see paragraph 21. In view of the observation and considering the fact that of the circumstances, I have no hesitation to hold learned trial court made gross mistake and error and decreed the suit in favor of the plaintiff by holding that the defendants are tenant as per the provision of the West Bengal Transfer of Property Act, or not West Bengal Premises Tenancy. This was, Milord, the point. Now, Milord, let me show your lordship the Milord, kindly see, Milord, this flag mark. This is, Milord, Makra Ek Number Gram Panchayat, Sujit Kumar Kal, Khajna Rashid. It is, Milord, dag number, Milord, scheduled property lordship has taken, Milord, dag number 735. Milord, they are taking Khajna of dag number 735, Milord. The Khajna has been deposited in Makra number 1 Gram Panchayat.
In contrary to that document, any document has been provided on behalf of the defendants?
No. Yes, the Shalishi was before the Shalishi was exhibit C was exhibited from on their side, and Milord, before that Khajna, we have also given, Milord, our LR record of rights, Milord, showing, Milord, dag number 735 is in Mauja Makra, Domju. My lord is
Exhibit C.
Exhibit C is
Shalishi.
that Shalishi. Exactly. This was marked from the side of the defendants. Yes.
Bearing the signature of the defendant?
Milord, they have given, it was marked without objection. Must be, Milord, admitted document.
No, actually, at the end, bearing the signature of a...
No, only the signature of the Pradhan. present is প্রথম পক্ষ সুজিত পাল and second পক্ষ is খলিল কুরেশি ভাড়াটিয়া and বাড়িওয়ালা ভাড়াটিয়া specifically mentioned. This is
It
the
has been relied by them, exhibit C.
exhibit C. And now Millard, the এইটা একবার দেখে নি। their death certificate also, predecessor's death certificate, Millard, is 12 এটা হচ্ছে মৃত বাঁকড়া, the place of death is বাঁকড়া মালানপাড়া। Millard, this is Millard exhibit D. Death certificate is exhibit D. This is also Millard Bakora Millard, where the Millard provision of Millard Howrah Municipal Corporation will not apply.
Where from it has been issued?
It has been issued by the Register of Births and Deaths. Register of Births and Deaths.
That will not affect.
Millard, HDO is the authority, Millard, under the Registration of Births and Deaths Act. HDO is the authority, but it is punched in such a way, Millard,
the main portion has been.
That the letter, this part, Millard, is punched in such a way, Millard, that I cannot.
Thankful that there is no stamp of the court above that, just above that.
No, stamp is just on the reverse side. Millard, this is what, Millard, is
Yes.
there.
Now, Mr. Hodajaji, any you want to rely upon any?
Judgment, Millard, tomorrow, Millard, I will rely upon, Millard. This is the facts, Millard.
So,
This
as
is,
regards to submission, complete.
but these are the, I cannot, Millard, tomorrow. Kindly see, Millard, section 111 of the Transfer of Property Act.
Yes.
Millard, kindly see 111. Millard, kindly see G. How determination of lease, how leases are determined, Millard. A, B, C, D, Millard, are other cases, Millard. We are not implied surrender. D, F, Millard. G, by forfeiture, that is to say, in case the lease breaks and an express condition that which provided that a breach, the lessor may re-enter, or number 2, in case the lessor re-announces the character as much as setting up a title in a third person or by claiming of a title by himself, or number 3, the lease is adjudicated lessee is adjudicated insolvent, and the lease provides that the lessor may re-enter on the happening of such event, and in case of these cases, the lessor or his transferee gives notice in writing to the lessee of his intention to determining the lease. H, on expiration of the notice to determine the lease, or to quit, or to intention to quit the property leased out duly given by one party to another. H is applicable in our case. H is applicable in our case. Well, that is determination. 111 H is applicable in our case. Now, Millard kindly takes up, Millard, the part of the evidence. Mark DW1. Milord,
কি বলে?
Milord, before the evidence, Milord, Milord, the written statement, Milord, has to be looked into. The written statement. ওদের DW1 টা বার করো, দেখিয়ে দিচ্ছি। Kindly see the first 6 paragraphs are only, Milord. Yes. Statement the appeal পরেরটা written statement তলায় না আরো তলা রিডিং তো
Only one plaint. No amended plaint.
amended. Yes, amendment was due to
How many
substitution.
times?
Due to substitution.
আচ্ছা।
Otherwise, Milord, I could not find. Kindly see, Milord, first 1 to 6. Paragraph number 1 to 6. These are, Milord, general denials. These are general denials.
Yes.
Then, Milord, kindly see paragraph 10. The statement made in paragraph 2 are false. It is false that the defendant is a defaulter in eye of law. The defendant files a separate petition under section 17(2) and 2A of the West Bengal Premises Tenancy Act 1956, denying all the allegations made in the plaint. Milord, this is their only statement regarding, Milord, the Premises Tenancy Act and the, Milord, Transfer of Property Act, jurisdiction of the suit. 1 to 6, Milord, are general statements. Every suit, my lord, will see. And apart from para 10, I could not find a single document which says, which has challenged the maintainability of the suit.
Against the application under section 17(2), you had filed an objection.
Must have.
What to have been?
দেখতে হবে 17(2). পাঁচ সাত মিনিট পাঁচশো টাকা বলে এক্ষুনি যাচ্ছি। এটাও তো নেই, শেষের দিকে আছে এই দুটো রাত।
It will be in the area of the applications. कुछ बोलবেন? এটা তো 1956 56 ঠিক আছে ঠিক আছে হ্যাঁ ঠিক আছে আর ওটা 1997
Milord, regarding that, Milord, I have stated in the third paragraph of my objection, para 3, that it is materially false. Ultimately, the dispute of enhancement of rent was decided at the office of the Gram Panchayat, or ultimately for intervention of local people. The rent was accepted at the rate of 65 per month. Is strongly denied. Milord, regarding Milord, acceptance as premises tenancy, Milord, no such. They have taken, Milord.
in the first few paragraphs nothing has been mentioned.
Neither neither tenable in law and facts, and is
That is evasive. There is no specific denial.
that yes, the defendant was always a monthly premises tenant in respect of the suit premises at a monthly rent of 200 as per English calendar month. This is what. They have also not taken, Milord. This is what, Milord. This is not there. Apart from this, Milord, no other statement is there.
What was the statement therein? What was the statement in the last statement?
Achha.
The objection, the objection.
পরে না 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 39 যা আগে ছিল না
না না আরো পিছনে
এইটা
বিমান ওইটা না ওটা একটু ওই যে এটা দিয়ে দিতে বলবেন পেজ মার্কেট করে
কোথায় হারিয়ে গেল এখানটা হবে objection. Benchmark.
that portion last
Oh. Acha, this is the language. There was no sitting. The plaintiff the plaintiff most humbly state that the defendant has been running a red meat shop since long from the suit premises, and he used to pay monthly rents to the previous landlord at the monthly rent of rupees 200 and not at the rate of rupees 40 or 65 per month. There was no such occasion to receive the monthly rent from the defendant by the plaintiff since after purchasing of the property. And another is is what? Oh, paragraph 3. My lord wanted to see paragraph 3. The defendant was always a monthly premises tenant in respect of the suit premises at a monthly rent of 200. This is what perhaps my lord wanted to do. Paragraph 3. Paragraph 3. Now, my lord, two set of my lord affidavit keep that to that. আমাদের না ওদের yes.
The 17.2 application was adjudicated on behalf of the petitioners. Somebody had deposed. He or she had been cross-examined,
Perhaps my lord 17 not on evidence.
not on evidence, only on affidavit.
আচ্ছা ওটাও দেখতে হবে। Milord, regarding Milord the affidavit in chief of the Milord DW1, Milord, this point, Milord, first paragraph 12 of the affidavit in chief of DW1, that there was a Shalish arbitration for settlement of disputes before Pradhan Bakrahat, Bakra Gram Panchayat, Roshan Diwan, dated 6th of January 1995, but the settlement was frustrated due to Shujit Pal, the landlord. It bears the seal and signature of the Pradhan of the Gram Panchayat number 1 exhibit, and this was Milord the exhibit C, Milord, from there. Therefore, this is their positive assertion. A positive assertion, Milord, the settlement was before the Panchayat. And Milord, the Khajna receipt and Milord, the LR record.
On your behalf.
Mouja Bakra. Mouja Bakra, the address of the Milord 106 notice was village such and such, village and PO Bakra. And they have received it there. AD card is there.
That is the address of the shop room.
Shop room. 1. Number 2 is, if your lordship would kind enough to see the evidence of the both the sides. First, my lord, the evidence of DW1 dated 3rd August 2016. August 2000 DW.
There must be some question put before the defendants, because the second issue is the suit governed by the Transfer of Property Act?
That is the question, my lord. My lord, I will also be reading the entire part of my evidence. It was their issue. Initial onus was them to prove. Then, my lord, if they have discharged, my lord, initial burden was upon them to prove. If they have discharged their burden, then, my lord, onus shifts upon the plaintiff. It was not the duty of the plaintiff to to prove this, because this issue was raised at their instance.
Whose suit it was?
My lord,
Whose suit it was?
my suit. Issue, my lord, who asserts has to prove. It was their case that they have issued. They have raised the issue. My lord, to prove that, my lord, the initial burden was upon them. Then if they would have, my lord, discharged their burden, then, my lord, onus would have shifted upon the plaintiff. To, my lord, what the plaintiff can do. Plaintiff has given his title deed.
Mr. Bhattacharya, you had to prove that whether the notice is valid or not. Issue 3.
That's all.
To prove that, you had to prove whether the property falls within panchayat or municipality. it is within the West Bengal Premises Tenancy Act or transfer of property.
Provided they dispute the notice. They have disputed the notice. Thereafter, what evidence they have given? This is Milord their affidavit in chief. এটা বার করো। তুমি এইটা বার করো 3rd August 2026 DW1. I will be reading the entire evidence and their Milord admission. 3rd August. এরপর একটা DW1. লেখো DW1 বলে।
Chief or cross?
Cross.
Cross.
Cross of DW1. ওটা affidavit in chief. Perhaps Milord, the learned trial judge Milord has marked this. It is thoroughly marked. Kindly read it to the other.
You have the copy? Thank you very much. The shop room is in Panchayat area.
Exactly. First line. This is their categorical admission. It is true that there was a meeting in the Panchayat to fix the rent. I have document to show that I have paid rent from 91 to the landlord. I have submitted these to court. These are the rent receipts and court challans. I have rent receipt of the previous landlord, namely Hori. I have not given rent to Sujit Pal as it was deposited in court. Sujit Pal never consulted me regarding his requirement. I have no enmity with the postal peon. It is not a fact that I am not a tenant in the suit premises. It is not a fact that Sujit Pal was not present in the Panchayat meeting. Therefore, it is categorical assertion that it is Sujit Pal who was present. It is not a fact that I have deposed falsely and my affidavit in chief is false. I have objection to the eviction decree. This is the categorical admission. And number two, my lord, one dangerous, my lord, observation has been made by the learned appellate court. My lord has seen that the lady who's deposing is the Pardanoshin lady, and he cannot, my lord, he could not understand what, my lord, was put to him. My lord, I do not know, my lord, whether this can be, she is stepping in the dock. It's not that, my lord, the commissioner is going and examining.
That's why the question was put from this end, that whether the sons were major or not.
My lord, that I do not know. That I do not know. Perhaps, my lord, this lady was in control of the business. She was, my lord, running the shop, my lord, that may have been.
Rashida Begum, by occupation business.
Well, she must be running the business.
Having enjoying its business at Dotala Jhil Mode, Bakra Police Station, Domjur. This is the suit property situated.
Yes, yes.
Dotala Jhil Mode, Bakra Police Station. Yes.
Now, my lord, if your lordship would kind enough to see the affidavit in chief of, my lord, the PW1, my client, paragraph 9.
Yes, paragraph 9.
Kindly see, this is the porcha marked exhibit. This is the Khajna receipt of Makada Gram Panchayat,
1 minute.
marked exhibit.
Paragraph 9.
9 and 10. May I find it out for your lordship?
No. Affidavit in chief filed on behalf of the PW1,
Sujit Kumar Paul.
Sujit Kumar Paul. This one, this only PW1, if it is filed in, you have stated that 17.2 was not
That's
decided
not
on
within
evidence.
my knowledge. I have to again check it up.
Obviously, this one will be in the
Suit it.
main, yes, main proceeding. It, you are placing the cross examination or?
No, chief.
Chief, yes, chief. Chief is paragraph 9, that I pray for a decree as per prayer of the plaint.
Later, আমাদের কি আলাদা নাকি?
Chief dated 20th July.
No, that is in my, that is, my lord, in my, I pray for a decree as per plaint is paragraph 29 in my copy. It is total number of paragraphs are 30 paragraph, chief. This is, I have a copy, which was filed on 13th August 2014.
কি অসুবিধা হয়েছে আপনাদের? এত কি গ্রেভ প্রবলেম হয়েছে? দেখবেন ছিঁড়ে না যায়।
Thank you, 13th August. Yes, ma'am, paragraph 9, that this is the Porcha marked exhibit. This is the Khajna receipt issued by Bankra 1 Gram Panchayat, marked as
And
exhibit.
the examination chief which was
Lord,
placed
this is
before you at the first
is also, my lord. Lord, this is also a chief.
How many examination in chief?
কে জানে? And I have this copy.
The court has 2 copies. Which principle of will have to be taken?
এটাও তো affirmed copy.
Is there any supplementary?
No, supplementary, it does not appear it is a supplementary. I do not know. My lord, I have, my lord, this one only.
The larger one.
Yes. Yes, 29 paragraph. This is what?
This is the Porcha marked exhibit. This is the Khajna receipt issued by Bakra 1 Gram Panchayat.
What is the purpose of? What is the purpose of, my lord, showing that? Marked without objection documents. Marked without objection.
On the basis of this examination in chief, cross examination took place.
Exactly. Now, my lord, I have the, my lord, copy of the, my lord, cross examination of PW1. My lord, not a single cross-examination was put forward to the plaintiff on this point. Not a single cross-examination. Single question was put on. If your lordship would kindly see the further cross-examination,
Dated 7/1.
no, on 2nd December 2015.
Yes, 2nd December.
Kindly see, my lord, 8 lines from the bottom. I have informed the local,
Yes, I have informed the local PS
yes, and local
panchayat
panchayat regarding the same
damage.
Therefore, inform to the panchayat authority. Inform to the panchayat authority. If the suit premises, my lord, was in the municipal area, my lord, I could not have, my lord, complained it to the panchayat authority.
Yes.
And apart from this, my lord, I could not find a single cross-examination in the entire, my lord, any question which was put to me, my lord, during the regarding the location of the suit property. Anything. Or denying that they are not the tenants under the plaintiff. Not a single question. My lord, these are on facts, my lord, and judgments, my lord, I will be relying upon, my lord, on
Lord Counsel.
Wednesday or Thursday, my lord, Thursday.
Lord Counsel. When can you?
My lord, next week, coming week. He'll be returning on Sunday. He'll be returning on Sunday. He's gone to Ayodhya.
I will be completing on Thursday. Next week.
The Learned Counsel representing the appellant commences his argument, submission. Stop. After submitting exhaustively, the Learned Counsel seeks an accommodation for placing the authorities on his behalf. Stop. Let the matter appear on
Thursday or
Thursday.
Friday.
Thursday.
Thursday, ঠিক আছে।
Thursday, August
Tuesday,
13th. August 13, 2026. For placing citations for judgments on behalf of the appellant. You have taken note of the points.
Nothing more is required to be placed on facts.
So on Thursday, 13th. Part 30. Appear under the heading part heard. ঠিক আছে? Will appear under the heading part heard.
Item number 3.
At item number 3, I am appearing on behalf of the appellant, my lord. My lord, I am ready with the matter, but my learned friend who is appearing on behalf of the respondent, she informed me that due to her some personal difficulty, she could not able to come today. So, my lord, let the matter be not today. Only not today will suffice.
Only not today will suffice. Order will require to be passed. Order is required to be passed. So it will appear tomorrow.
Grateful much.
Not today.
Not today.
Item number 4.
এটা খুবই mentioned কেন আসবে? না না না, আরে চেঞ্জ হবে তো, যেখানে হিয়ারিং আসছে হিয়ারিং হয়ে যাবে, টু বি মেনশন। হ্যাঁ, টু বি মেনশন কেন? Judicial miss case being number 127 of 2023. Pending before the Learned Civil Judge, Junior Division, First Court, Midnapur. That order has been placed. Order dated 23rd, 26th of June 2023.
Kindly go through the order passed by your lordship in this matter on 21st of May 2020. It has been considered by your lordship and thereafter direction has been passed upon the minister. আর আগে প্লেস করা হয়ে গেছে 21st of May 2024. Order passed by your lordship in this matter.
দেখুন লুজ হয়ে যাচ্ছে খেলে।
May I hand over?
না না, বিমান বাবু, এই দেখুন এটা লুজ।
Madam, sorry for intelligence, my lord. Since inception of this matter, my lord, I have raised the maintainability point, my lord.
বাবা, কিছুই তো
আমি inception শুরু থেকে
Taken care of by your lordship on 21st of May 2020.
representing the private respondents submit that inadvertently on the earlier date, the photocopy of the order passed by Learned Civil Judge, Junior Division could not be furnished. পরে করবেন সরুন, এগুলো দেখে নেবেন, দেখেননি তার মানে। The learned-
Take the order.
Yes, yes.
Then may I read for your lordship?
Submit that the photocopy will be furnished today itself prior to recess. As the photocopy of the aforementioned order has been filed today, so the order dictated in open court and was being passed. The affidavit of service has been filed. Let the affidavit of service be kept with the record. The learned counsel representing the petitioner submits that a construction has been completed at Moja under the Midnapur municipality. Further submits that the sanction has been illegally granted without following the provisions as laid down in the municipal building rules. Further submits and challenges the reasoned order passed by the chairman, the Midnapur municipality, and also challenges the decision taken by the Board of Councils. Challenging the reasoned order passed by the chairman, Midnapur municipal responsible letter sent by the petitioner. For counsel, the letter representing the private respondent, that is the respondent also challenges the maintainability of the instant writ petition on 3 grounds. Firstly, on the ground that the writ petition is standing to file this writ petition is litigation and has relied upon the council has also challenged that this forum does not have the jurisdiction and appeal is to lie before appropriate forum, has also submitted that this is not a case of construction in the basis of unsanctioned plan. Instead of construction in accordance with the plan sanctioned by the Midnapur municipality. It's further submitted that an appeal has been preferred with private respondent before the appropriate forum against the order of demolition passed by the court, and therein an order of stay has been obtained by the private respondent. In support of this contingent, learned counsel has furnished a photocopy of an order regarding the certified copy transfer of Board of Councillors is not only the sole respondent, the writ petitioner is also party in the list. The learned counsel representing the Midnapur and the respondents of the 2 and 3, that is the Board of Councillors, and the chairman of the Midnapur municipality submit that he will respond with the submission of the learned counsel representing the private respondent, and in support of his convention, the learned counsel has placed the reason for the chairman, Midnapur municipality. After hearing the learned counsel representing on the side and in favor transfer the documents, relying upon the report of technical staff of Midnapur municipality to the spot therein it has not been specifically mentioned as to the person who has signed the report. The second will there be an inspection by the competent person of the brings about the petitioner and the private respondent on 19 as well as petitioner and the private respondent or the inspection is the Yes.
For the submission.
kindly reduce, my lord, before you
Sir,
lord
আমি
proceed
একটু বলে দিই,
further.
স্যার,
The
আমি বলে দিই, আপনি আগে দিয়ে submission টা করুন।
218 subsection 3.
Mr. Basu, let him
So far,
submit.
the objection
with-
raised by my landed senior friend on the last occasion,
Hmm.
that has been taken care of by your lordship.
Hmm.
And thereafter, direction has been passed upon the municipality to conduct an inspection.
Hmm.
And that order has not been challenged by any of the parties.
Hmm.
They have accepted and the order has been acted upon.
Hmm.
An inspection was conducted on the basis of this order.
Hmm.
Today, whether my landed senior friend can take this point or not.
Hmm.
And there is a direction to submit the report. Whether municipality has submitted the report before lordship, I do not know. I have no copy has been supplied to me.
Yes.
This is the issue first. Your lordship has to decide first. Let this municipality file the report first, my lord.
Yes.
Now may I?
Anything more?
For the timing.
218 subsection 3.
Yeah.
Hey, admitted fact, there is an order of demolition. Admitted fact, invoking 218 subsection 3, appeal has been preferred. Stay has been granted. There is a specific alternative remedy has been invoked.
So you are relying upon
Subsection 3.
subsection
I am
3.
sure my lord is not exercising your lordship jurisdiction to decide the appeal which has been pending and before the statutory appellate forum.
You are representing the private respondent.
At by instance, I prefer an appeal as per 28(3. Stay has been granted. And I am sure, my lord, on that date, this provision has not been placed before my lord.
Learned Senior Counsel, on that day,
My lord.
21st of May 2024,
Yes.
the
There is
private
secret order.
respondent was represented.
Yes, it has not been placed. Maybe represented, my lord.
We are not.
Kindly, this is a question of law. I am not facing any fact which is missed by them. Kindly peruse, my lord, the statutory provision invoked. Whether after invocation of the statutory provision, the writ is maintainable or not.
There is C that has been pointed out.
Fact has been pointed out, not the law.
Landed Council has further submitted that the appeal has been prepared by the
Yes.
private respondent before the
Yes.
appropriate forum against the order of demolition passed by the, therein an order of stay has been obtained by the private respondent. In subcopy is contained, he furnished photocopy on perusal of the certificate copy of certain sir. Just a second, lord.
My lord, will not decide the appeal.
Until unless this order stands, there cannot be, I think my landed senior friend cannot take this point until an order being recalled or being stayed by the division.
It has been
That has been
correctly
acted up.
raised. It has been correctly raised by the Learned Counsel on behalf of the petitioner. Once an order has been passed,
Right. Without looking into the statutory provision of law.
that is,
Before my lord, I am saying, I am not preferring any appeal, not. I can demonstrate before my lord that my lord's was lordship's.
so in such circumstance, something is to be, some step has to be taken.
Subject to correction, no steps. If you can bring before the court that order has been passed without placing the statutory provision before my lord, this is the council's duty to place it. Not
At,
placed.
at that relevant point of time, a learned,
Act was placed.
a learned counsel had represented the private respondent.
But this law has not been produced.
Yes,
There is no finding, my lord, I don't find.
that is also a
Had it
fact.
been case, my lord,
That is also a fact.
if law is been
Section 218, subsection 3
is the
was
statutory
not placed,
provision.
was not placed. So
That creates. My lord,
that creates
if your lordship asked me to go for order 47 and apply, this is the read code I can point out before my lord. Suppose today, my lord, a judgment has not been placed before my lord, which squarely says, I have the judgments also, when the read court can interfere if the alternative remedy is not invoked. If it is invoked, the read is not maintainable.
learned counsel, an application in this regard. Anything more to be said from
I
this
can
end?
only say,
Yeah, please keep talking, you know.
I can only-
Anything more to be expressed from this end?
No, I
An
understand.
application,
My lord, I understand, my lord. When the my lord has opened your lordship's mouth, I understand my lord is heading me on that line. You file a 47 application or recalling application, whatever in the nature.
I am not suggesting
Under
under
laws of
which,
jurisdiction.
Huh?
Advising jurisdiction lost long back. I'm not
Today, my
asking
lord,
for
there
that.
is a direction
So,
passed
okay,
by your lordship.
Very well, my lord. I will file an
But
application.
today, there is a direction on that day, there is a direction upon the municipality to file a report. Whether the report has been filed or not, I do not know.
Not
Whether
fine.
the report has been
Not
prepared or not. Long back the order has been passed, till today inspection has been conducted. On the date of inspection,
I
I have
was
submitted my.
Really, my lord, had it this order was not known to me. Had it been known to me, my lord, I could have steps. Because I thought on the first day when I appear, I produce this order.
that is
It appears that earlier also the
just a few days ago, but this
But,
order has been, this order has been passed in the month of May
24.
2024. And
This order was not known to me. Mr. Basu is not aware of this order.
yes. And the court was also not apprised of section
My lord, I
218
understand
subsection.
my lord's difficulty. Kindly give me 1 week time. Or let me come with an application for recalling.
So far the report is concerned. So far the report, you are why they are not there. Order has been acted upon, you have not filed the report.
Order has not been acted upon.
Yes, they have
because-
conducted inspection. On the date of inspection, I submitted my representation to my learned advocate. This is received by the municipality.
I will take instruction. I will take instruction.
What instruction? You have conducted the
Learned counsel,
inspection.
Long back.
when
Inspection. এই তুমি দেখো না মেজারমেন্ট কবে হয়েছিল কি দাদা তোমরা
I can only say, my lord, this exercise is futile. The appellate court, who is
But-
the citizen of the
but
your lordship's order should be complied with. I can.
we will
understand.
have to abide by the provisions of law.
Yes. But if today, my lord, the exercise which my lord has directed to inspect, and this is absolutely, according to me, don't take me a message, futile. Because appeal court is citizen of the matter.
Until and unless
This is order is recalled. Give me that breathing time.
The
1
report
week.
has to be filed. Your lordship
Give us
will
1
recall
week
your
time,
lordship
we'll come. If my lord thereafter says no, this order has to be complied with, we are bound to comply.
Suppose my learned significance is appearing for the private respondent, there is a direction upon the municipality to submit the report.
there's learned counsel representing the which municipality?
Midnapur
Midnapur municipality.
The private respondent.
You are not aware?
I have to take instruction.
He had appeared on that
Nin.
day.
Nin.
Oh, Dada.
Nin. For the Midnapur municipality, Mr. Sujoy Bandopadhyay and
My lord.
Mr. Pradipto
My lord.
Siddhanto had appeared.
Appeared on that
I
day.
appear. Appear.
The learned counsel, the learned counsel representing the petitioner submits that the order passed by the learned civil judge junior division first court Midnapur in judicial যেটা ধরতে পারবে না বলে দেন in judicial miss case 127 of 2023 was earlier placed and dealt with by this court in presence of the representative, in presence of the learned counsels representing the petitioner, the private respondent, learned counsels representing the petitioner, private respondent, and the Midnapur municipality. Full stop. As such, and through the order, but wide order dated 21st of May 2024. There was a direction of causing an inspection by competent person of the Midnapur municipality in presence of both the writ petitioner and the private respondent on 19th June 2024. Full stop.
On the date of inspection, 19th inspection was conducted. And previously, I have submitted this one. On the date of inspection, I submitted this one. You understand?
The learned counsel has further submitted that on 19th of June 2024, inspection has been conducted by a competent person of the Midnapur municipality, and on that and during that occasion, some documents. Learned counsel, if this document has to be taken into consideration, then this will have to be placed.
I will now. I said that I have placed this on the date of inspection.
I am not taking into consideration now, only recording your submission.
Kindly record.
Some documents were
And
placed.
document,
Some documents were placed on behalf of the writ petitioner.
I
Full
have
stop.
advocates dated 21st of June 2024.
Wide an advocate's letter dated 21st of June 2024. Full stop. Paragraph. The learned counsel representing the Midnapur municipality submits that he does not have any further instruction as regards to submission of report. Full stop. The learned senior counsel, paragraph, learned senior counsel representing the private respondent seeks at this point of time, the learned senior counsel representing the private respondent seeks an accommodation for a week to take steps in this regard. The learned senior counsel also submitted that this court does not have the jurisdiction to take up the matter at this stage after an appeal being preferred before a court of competent jurisdiction. In support of his contention, the learned counsel has placed section 218 subsection 3 of the West Bengal Municipal Act 1993. 218 section 218 subsection 3 of the West Bengal Municipal Act 1993.
Next, we will clear the doubt from the minds of people.
Let the matter
Should have
appear.
been pointed out.
That's why the assistance of learned counsels are required.
Should have been pointed out. There's such a minimum thing. But,
But that was pointed out.
My lord, isn't it? I raised my voice.
That was pointed out.
raising
Yes.
his voice,
Question, 15 তারিখ।
raising of voice, Mr. Bandyopadhyay is always. That we will not do.
স্যার, স্যার, কবে বলেছে? 21 তারিখ?
No,
What is
if
that? Yes.
learned counsel, if if that point, that section had been raised,
Certainly, my lord. The manner,
that
the manner,
should
my
have
lord,
been
proceed.
reflected in a long order of 4.5 pages.
My lord's procedure is to point out, record everything
Yes.
which has been placed.
Yes.
That's my lord's procedure. It had not been placed.
But according to my landed friend, he has placed that point, but however, he has not applied the order passed to the lordship so far inspections.
Out of course, the answer reply to my lord, I'll come back, my lord.
Okay.
Let the matter,
From Ramlitarar naki?
let the matter appear on
Next Tuesday,
Tuesday,
I file
18th,
that application before that.
being served upon the
30.
18th of August,
Make it 19th.
19th of August. 19th of August.
এসব বলছে শুনতে পাচ্ছিস? চল,
এটা actually-
My lord, I am praying adjournment on behalf of Mr. Ganesh Srivastava, my lord. In this matter, Mr. Srivastava appearing, my lord, making only not today, my lord. Here, yesterday he said that he will not come
No,
today.
this matter is not that one.
No,
which
that
was
one,
taken
not
up
that one,
yesterday.
not that one.
In this matter, I am appearing for the Board of Work.
This is separate matter, civil revision.
Not today only,
Only not today.
because Mr.
He-
Srivastava will appear tomorrow only
my lord, he will come.
in that matter.
Yes, yes, yes.
Learned advocate representing the
The slip like that, the slip down.
learned advocate representing the petitioner. Seeks an accommodation for this day on the ground of his senior. Full stop. Considered, allowed. Let the matter appear tomorrow. That is 12th of August, tomorrow.
Yes, my lord.
For the petitioner.
I beg to appear on behalf of the plaintiff opposite party number 1, 2, and 3.
My lord, what happened, my lord, in this matter? One
minute.
partition shoot,
1 minute, learned counsel.
one partition shoot at the.
1 minute, learned counsel. How many
My lord?
opposite parties are there?
Yes, yes.
Respondent, you are representing 1, 2,
Plaintiff, all plaintiffs.
1, 2, 3. Respondents, plaintiffs.
Plaintiffs opposite parties. This is a civil divisional application.
My lord, local club also implicated in the matter.
The remaining persons are
তোমরা সবাইকে represent করছো?
and the
He is
remaining
representing 1, 2, 3.
1, 2, 3.
1, 2,
Remaining 4 to 33.
they are all pro forma.
What about 34 and 34? Yes, 34. Presence not required.
It is Durga Puja committee, no, my lord, the partition should filed by, my lord, the plaintiff opposite party.
Hmm.
And wherein, my lord, I am the main defendant, property, my lord, the distinct property out of, my lord, 8 decimals of property, wherein, my lord, a 2-storied building was there.
The entire property belongs to both of you.
No, no, no. Only myself and my wife. I have purchased a property that is a 2-storied building.
which comprised of 8 decimals of land.
The entire suit property.
Entire. This is the entire, no question of partition. So in a suit,
1 minute, 1 minute. And the partition suit has been filed by them.
yes,
How can it be?
they are answerable. We have filed written statement. We opposed it. Even we filed my lord, written objection against the order of status quo.
So, what was the injunction?
Injunction, my lord, restraining me, my lord, from doing any construction repairing works, my lord.
You have come up, the impugned order is passed in misappeal. What was the injunction order
Injunction
passed
order,
by the trial court?
yeah, injunction order is
Have you
restrained.
furnished?
That has not been annexed.
Status quo,
In which page?
and restraining me from doing any construction work,
Lord Counsel, in which page?
my lord.
Ad interim or temporary
Final,
injunction?
final. Against final order, my lord, I moved the misappeal and misappeal dismissed.
In which
Against
page-
that,
In which page it is?
my lord, misappeal.
Not, I have got the misappeal. That's the impugned order.
Impugned order in the
Impugned order I have got.
trial court.
The order of
That is not,
injunction.
that is not impugned. Impugned is, that is
At
marched.
At least that is known.
Is marched.
The impugned
is-
order has been passed in the misappeal.
Yes,
I am seeking the order passed by the trial court.
just in.
Temporary injunction order passed by the trial court.
Yes. That is, I am sorry, my lord, that is to be annexed, my lord, that is not annexed, my lord.
20th of September 2024. That is the final order of injunction passed by the learned civil.
Against which they had preferred misappeal and
They have lost their
this is the
as well.
impugned order.
Yes.
Let us go through the order passed by the trial court.
One.
Not required to be gone through.
Below that apart, I have one more submission that other respondent,
Let him,
other opposite parties are the co-sharer. So they are the necessary party because this is a partition suit. But he is
the
saying,
remaining opposite party,
yes,
are
they are the
co-sharers.
co-sharers. The
including that 34.
No, not 34. 34 is secretary because he has that particular club has acquired some portion of the land which has been acquired by the state government. That is why
Estate to the state government.
the originally, my lord, the property was owned by Anandamohan Dhali. Now, Anandamohan Dhali owned 23
Your
decibel of
predecessor?
land.
Your predecessor.
Yes, our
My lord,
predecessor.
page 69, kindly come.
No, this is the interim order. The final order has not been annexed. Annexure 6, page 69.
This is the order of ad interim injunction.
Yes. This was made final. The plaintiff have moved.
No, this is not known to us.
My lord, kindly, my lord, go through this order, my lord. Let me go through this order. The plaintiff have moved an application for identity injunction. It appears from the report of the solicitor that no caveat has been filed and is pending till late date in the present suit. Her learned advocate for the plaintiff peruse the plaintiff injunction application as well as document filed by the plaintiff. Considered, it appears from the plaintiff that an application that Schedule C mentioned property is the undivided property and both plaintiffs and defendants are co-sharers in respect of the same. The plaintiff, though plaintiff number 3 on 1st April 2023 asked the defendant number 1 and 2 for effecting amicable partition of the Schedule C mentioned suit property by meets and bounds according to the respective shares, but the defendant number 1 and 2 not only flatly refused to make such partition but also openly violently denied the title of the plaintiff over the C schedule mentioned property. The said defendants also made attempt to raise new construction on the entire C schedule property and also tried to change the nature and character of the same. The plaintiff have thus filed present application as spread for relief. it appears at this stage a prima facie Schedule C mentioned property is joint property of the both plaintiff and the defendant. Concerning materials on record, I am of the view that the suit court is required to be preserved in its status quo at this stage. Hence, it is ordered that both parties, plaintiff, defendant number 1 and 2, directed to maintain an investment of the nature, character, and position of the Schedule C mentioned suit property till 19th April 2023. Later,
Lord Counsel, place the plaint,
my lord,
place the plaint,
yes, my lord, which is very much relevant, and C schedule property, that also very much relevant. What is the C schedule property?
First,
Yes, plaint 22.
The court wants to know as regards to the status of the remaining defendants.
My lord,
3 to 34.
my lord, they are
What has been mentioned?
unnecessary implicate. You have to make hotspot to my claim. My lord, a property, a two-story
Place the plaint.
shoot for page 22, shoot for declaration valued at ₹100, shoot for partition 1,20,000, shoot for injunction 100. My lord, that all a piece and parcel of the landed property measuring 23 decimals. This was my vendor's predecessor, Onadi Mohan, measuring 23 decimals, comprising old Dag number such and such, under the old Khatian number such and such, district Howrah, subject matter the present comprehensive suit. The said 23 decimals of landed property has been more particularly described A schedule mentioned herein below and referred A schedule of the suit property for the purpose of clear distinction, identification, and or specification, and or having a glimpse of the suit properties. One handmade rough sketch map has been annexed with plaint and said rough sketch map. The above mentioned property, that is the A schedule property, has been shown and or dealt with delineated in color blue border. The said rough sketch map annexed to it. That originally the said entire A schedule suit property belonged absolutely and exclusively to Ananda Prasad Dhali. 23 decimals of land, son of late Fakir Dhali, who had been possessing, enjoying, and occupying his said property peacefully, continuously, uninterruptedly by exercising all acts of ownership and possession thereon without any objection or obstruction from any corner in any manner whatsoever at any material point of time, to the knowledge of everyone concerned and to the exclusion of all others, against the whole world, that is right in dream. That subsequently at the lifetime of the said Ananda Prasad Dhali, the Land Acquisition Department, Government of West Bengal, in connection with LA Collector case number 28 of 1965-66 under the Act 48, acquired about 15 decimals out of 23. 15 decimals acquired by the state of West Bengal for construction of road. Land out of the said 23 decimals of land, that is A schedule property. So A schedule is 23.
Entire
Entire.
which belong to Ananda Prasad.
Ananda Prasad, my lord. Situated northwest, A schedule suit property from the said Ananda Prasad Dhali for the purpose of construction of creation of the PWD metal road running from Sarenga such and such. So from 23 decimals, 15 goes to the acquisition process, and thereafter remaining 8 decimals of land. The said requisition notice was duly sent in the name of said Ananda Prasad Dhali, and the same was duly served upon him in connection with the LA case 28 of the year 1965-66 by the concerned department in due official course personnel. The said acquired about 15 decimals of land out of total 23 decimals of suit property has been more particularly described in and or is hereinafter referred to a B schedule property. That 15 decimals mentioned below. The said B schedule property has been clearly distinctly shown delineated in color green. So green
Out of 23, 15 goes.
15
goes
goes
for road,
and it is B
metal road.
schedule.
B schedule.
Total 23 A schedule, B schedule 15. Now remaining C schedule 8 decimals of land.
Now we are confined to
8 decimals.
8 decimals
My
of
lord,
land.
my lord.
Schedule C.
Now on 8 decimals of land, my lord, by a deed, registered deed, my lord, I am sorry, it has to be annexed, my lord. By registered deed dated December 15, 1st December 2015, all the legal heirs of Ananda Mohan Dhali transferred the same in favor of Sri Biren Hathi, who happens to
Whom you are representing.
Biren Hathi is my vendor. And Biren Hathi purchased in 2015 from the all legal heirs of Ananda Mohan Dhali, the original owner,
The remaining entire 18 decimal.
where two-story building was there.
We are not concerned.
Yes.
8 decimals.
8 decimals.
Remaining entire 8 decimals.
8 decimals. When? December 2015. And my lord, December 2015, my lord, I am
1 minute. Purchased by whom?
purchased by Biren Hathi.
On
1st December 2015.
From all the legal heirs.
All the legal heirs, that means, my lord, my lord, kindly have a look, my lord, page 68, a genealogical table. Page 63.
68.
68. My lord, kindly have a look. Ananda Prasad Dhali, my lord, got it?
Yes,
Page
Ananda
60.
Prasad Dhali.
Dhali died on 8 December on or about 1970. Having, my lord, 4 legal heirs: Kalidasi, Kalibala Sardar, wife of late Sannasi, that's answer. Deed to Brojobala Bachar, wife of late Madan. These are, my lord, daughters.
2 daughters.
And Gunodhar Dhali. Dhali, son, and Jurobala Juramoni Gayen, wife of late Gangaram, also 1 daughter.
So 3 daughters and one son.
One fourth. Now Gunodhar Dhali.
When did
And Gunodhar Dhali.
When did this person purchase? Biren Hathi purchase on 1st of December 2015. At that point of time, whether wife of Ananda Prasad Dhali was alive, or has she expired?
Yes, no. Wife was not, because in the genealogical table says it describes 3 daughters and 1 and wife. 3 daughters and 1 son.
3 daughters and 1 son.
1 son. Now, my lord, kindly see who is figuring, who is transferring, who are the person transferring the 8 decimals of land in favor of my vendor. namely শ্রীমতী মীরা ঢালি, স্বর্গীয় স্বামী স্বর্গীয় গুণধর ঢালি। That means Gunodhar Dhali, that is the son, daughter-in-law of Anadi Prasad. Sorry, Anando Annoda.
Wife of Gunodhar.
Gunodhar, because Gunodhar also died by that time. Samod Dhali, son of Gunodhar. Ubhay Shank such and such, Jela such and such. Now, Simoti Jhorna Mondol.
Next.
Sami বিদ্যুৎ মন্ডল। নেক্সট শ্রীমতী বীণা সরকার,
বিনা না বাণী,
বাণী সরি বাণী সরকার, স্বামী ওমপ্রকাশ সরকার, শ্রী ওমপ্রকাশ সরকার। শ্রীমতী রীনা মন্ডল, স্বামী সঞ্জয় মন্ডল, মন্ডল। শ্রীমতী বীণা নস্কর, স্বামী শ্রী দিলীপ কুমার নস্কর। বাস all are there, excepting those there are none. Annoda Prasad Dhali, all legal heirs are here.
What about Kalidasi, Brojobala Bachar and Jurabala Juramoni Gayan?
From their genealogical tale can be read.
Now, my lord, see.
You have purchased from all the legal heirs of Gunodhar Dhali.
Gunodhar.
So you have purchased 1/4 share. The remaining 3/4?
My lord, I am going through the details, the recitals of the deed.
Yes, yes.
কস্য ওয়ারিশ সূত্রে প্রাপ্ত নিম্ন তপশিল বর্ণিত রায়ের দখলে জমি ডাঙা জমি জমা যাবতীয় রায়ের চত্বরি সাপ বিক্রয় করবলে জেলা এত সাচান সাচ এটি 8 শতক জমি আরো অন্যান্য শতক গুণধর ঢালি।
Let us return after the recess.
My lord.
Item number 8. Would you not just pleasure to take it up on next to it?
Tomorrow.
Oh, my lord, Wednesday week.
Learned Council, Wednesday week cannot be. Tomorrow it can be. Tomorrow.
My lord, in item number 8, yeah.
Yes, one minute.
My lord, I will take up of the day after tomorrow.
Learned Council, let there be someone. You may go. Let there be someone to respond at the time of call. Let there be someone to respond at the time of call.
So I am not here.
Yes. Stating your absence, that will be considered. And the matter will be, you are the opposite party.
Yes, my lord.
The matter will be kept.
My lord,
They give the
actually,
day after tomorrow.
Day after tomorrow. It will be taken up on day after tomorrow.
Actually,
But,
my lord.
but the order cannot be passed at this juncture. When called, let there be someone to respond, and at that time order will be passed.
We are praying, my lord, that the matter will be placed on next Monday.
Learned Council, have you heard what I have submitted?
Yes, I have heard.
I have not stated anything. I have submitted.
I will be there. I will be there. Okay.
Huh? দেখুন, হ্যাঁ, কন্টিনিউইং ম্যাটার কত? কন্টিনিউইং ম্যাটার 6। এটা কি দরজা খুলে উনি কি দাঁড়িয়ে আছেন ওখানে? দরজা খুলে ওখানে কি দাঁড়িয়ে আছেন উনি? হয় ভেতরে আসুন না বাইরে যান।
ভেতরে আসুন নাহলে বাইরে যান।
এই আস্তে 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 আস্তে। পজ আছে তো? পজ আছে তো?
হ্যাঁ হ্যাঁ
Yes, showing.
No, no, no.
ফোন নাম্বার নেই তো তোমার? এখানে তো অন্য একজন অ্যাডভোকেট আমরা দিয়ে দেবো।
ওই করে দিন, কি বলে, চালু করে দিন, চালু করে দিন। করা আছে?
The board is on, Milord. I have checked.
কত কিছু আছে এখন হয়নি নাকি? হুম। হুম। Okay, okay. Hmm? Hmm. Find out. দেখি বাবা। পেট ভর্তি করে খাবার খাচ্ছে, পেট ভরে খাবার খাচ্ছে। না খাওয়াই হয় না। My lord, I think today I would not be in a position to conclude the matter because, my lord, before court number 3, I have some urgent matter.
And
I thought that
Till-
only original side matter will be taken up, but only
till
after.
yesterday,
Yes.
these matters were very much urgent.
Very much urgent. My
Very,
lord,
very much urgent.
very much urgent. My lord, because, my lord, the deed which I am on, the deed 2015,
Hmm.
2000, that deed, this suit is nothing but challenging the deed of 2015 in a suit of 2023. So if, my lord, I refer the said deed, it will appear.
One thing, neither the deed of 2015 has been produced, nor the impugn order, the first court order has been supplied, annexed with this.
Just
It
a
will be
minute.
supplied to us so
It is
that
of yours.
neither it has been produced before the learned trial judge.
At the
My
time of hearing of the injunction application before the trial court and before the appellate court during misappeal, was this deed produced?
Must have.
Must
Must
have.
have. Because
Taking into
why I am relying on this deed, I also during the motion stage, I relied on this deed because 2015 deed, it is a transfer by the legal heirs of my lord, Annoda's only son,
So till now, as per the deed dated 1st of December 2015,
wherein, my lord, the witness is Ajit Bachar, who is the husband of plaintiff number 1. So,
Lord Counsel, let us go into the merit first.
my lord.
Therein, the persons whose name appear as sellers are Mira, Shomor, Jhorna, Bani, Rina, and Bina. 1, 2, 3, 4, 5,
altogether
6 persons.
6.
These 6 persons are the legal heirs of Gunodhar Dhali. Gunodhar Dhali is the
Only son of Annoda,
only son of Annoda,
the original owner.
original.
Now the genealogical table is relied on by the plaintiff. It is not my document. I am not admitted.
Do you say that Kalidashi, Brojobala, Bachar, and Jurabala were not given any share?
I am disputing the genealogical table. 7 except the Gunodhar. Gunodhar, that is the son of Annoda, that is correct. I am on that. But this genealogical table relied on and prepared by the plaintiff, and they relied on before the suit, and it is annexed in the plain. So in my written statement, I disputed. I am not admitting. I have not admitted that the genealogical table is the correct position, and the Gunodhar was the. My lord.
Mr. Poddar,
My lord.
the fact is that, do you deny Kalidashi, Brojobala, and Jurabala as the legal heirs of
Annoda
Prasad Dhali?
wife of daughter of Annoda?
Or do you deny that these daughters were not given any share of that property?
I am disputing because it is reflected in the written statement. I just referred before your lordship, and there was a record of rights.
You have filed written statement also.
Yes.
You have filed written objection also.
Yes.
And
my lord, in record of rights, only, my lord, this Gunodhar's name is appearing as the owner of the 8 decimals of land after
Learned Counsel, can we take into consideration from the record of rights that he is the owner and the other persons are not the owners? Does record of rights signifies the ownership?
These record of rights are there soon after the death of Annoda.
Whatever may be.
With full knowledge of.
Does a record of rights signify ownership?
It is not in full, but it is a corroborating piece of evidence because this Annoda died.
Then court will have to say that only signifies possession.
Yes.
Not ownership.
Yes, and I am in possession. We are in, Gunodhar was in exclusive position, and Gunodhar, my lord, transferred
Might be in exclusive position,
without
But
any
that-
interference,
but-
without any shoot,
but that,
without any challenge from any corner.
but that does not signify that Gunodhar was the sole owner and there were no other co-sharers to that property.
My
Does
lord,
it reflect so?
my lord, after the death of, my lord, first I am disputing the genealogical table. It is not a creation of the defendant petitioner. This is the creation of the plaintiff for the purpose of the suit.
Hmm.
And my lord, the record of your lordship is perfectly correct that record of rights only, it is not a symbol of ownership. Symbol of ownership is the deed. Symbol of ownership is the decree of the court. Symbol of ownership is the possession, uninterrupted possession. I think your lordship
That also, to the extent that he is in possession,
My
he
lord.
if there are other co-sharers, these co-sharers are having possession, constructive possession, as because
My lord,
Gunodhar, one of the co-sharer, is in
for that
exclusive
reason, my
possession.
lord, for that reason, I am showing, my lord, your lordships, that the deed executed by Gunodhar's legal heirs, all legal heirs,
Hmm.
wherein as a witness, Ajit Bachar, who happens to be the husband of the plaintiff number 1, is there. So this transfer was with full knowledge of all the alleged legal heirs as per genealogical table. So a transfer of December 2015 can't, by no stretch of imagination, can be challenged or disputed in a suit of 2023 after lapse of 8 years. For that reason, in written statement, the defendant's stand was the suit is not maintainable at all.
What are the prayers in the plaint?
Yes, cancellation, challenging the deed.
Page 38.
Well, just a minute. Page 30, affidavit. 38, inner page 21. First, plaintiff therefore humbly prays for decree declaration that registered deed of conveyance as described in item number 1 and 2 in the D schedule below to the plaint are illegal, void, fraudulent, invalid, vague, baseless, and not binding upon the plaintiff as well as upon the defendant number 9 to 31. This is the deed that is to 2015.
The plaintiffs therefore humbly pray
De-
for a
de-
decree for declaration
Hmm.
that the registered deeds of conveyance, registered deeds, two deeds, or two or more, plural, as described in item numbers 1 and 2 in the D schedule below to the plaint are illegal.
That is this deed. Reference page 40, item number 1. The date of
Item
execution
numbers
27 November 2015.
D schedule.
So, my lord, in sum and substance, the object of this
Item number 1 is the registered deed of sale dated 27/11/2015.
this
And
deed.
the item number 2 is deed of sale dated 6th of March 2023.
In favor of my client.
These two does not refer to the deed dated 1st of December 2015.
So, my lord, kindly see the number. A same deed. There are no other transaction. Number is, my lord, volume number 0501 of 2015. Here 0501 of 2015. Volume number is same. My lord, date of execution, my lord. একবার জজ সাহেবকে এটা একবার দেখিয়ে দিন, আমি ফেরত নিয়ে নিচ্ছি। ওই নাম, my lord, kindly see right hand top.
Yes, right hand top at the top.
With the schedule. 0501 of 2015. So, my lord, 2015 deed, I am putting question to myself. When the plaintiff having full knowledge and they participated in the process, can they challenge it? Are not they stopped from disputing the correctness of the execution when they themselves participated?
It was executed on 27th day of November 2015.
Yes. I think, my lord, I, my lord, submitted my wrong date because it's a certified copy, probably. So December date was there.
No.
Execution
It
is
was
November.
executed on 27th of
Yes,
November,
yes.
and it was thereafter completed
Yes.
and in the registration
by
office on
December.
1st of December
My lord,
2015.
my lord. So the number is, since the number is telling, my lord, so my lord, my contention, my submission before your lordship, this, the deed of partition, in disguise, a suit for cancellation of the deed. And my lord, in a deed, when, my lord, the plaintiffs are, all the plaintiffs are in well aware of the execution and they participated in the deed. So what from?
They have signed as a witness.
Yes, signed as a witness.
Witness to the execution of the deed.
Execution of the deed, knowing fully well what is this. It is not that. It is not, my lord, what property is being transferred.
Execution of the deed is separate from the contents of the deed. They are witness to the execution of the deed.
Yes.
Not to the contents of the deed.
This is a arguable one. This may rebuttable, but initially I can suggest, I can submit that knowing fully well the contents of the deed, there was no dispute, no denial, no statement, no averment in the plaint, in any of the paragraph, in lengthy plaint, that my husband participated without knowing the contents of the, without knowing the schedule of the deed, without knowing the purpose of the witness, remaining witness on that registered instrument. There is no such averment. So that goes to show, in absence of the averment.
This is a deed of 2015.
15, my lord.
And they are sought for declaration in the year 2023.
Suit number is 170 of 2023. Perhaps.
So you can say that after 8 years.
24.
23. 170 or 23.
So it is limitation is 3 years. So it is after 8 years. So in disguise, the suit is not for partition. The suit challenging the cancellation, challenging this deed, which has already been accepted. And if it is accepted, they are the legal heirs.
There has been an order passed to maintain status quo in respect of nature and character of the suit property.
And construction.
So you have been restrained from constructing.
I need some repairing. Lordship, kindly allow me to repair. I will contest the suit. No problem. I am not flooding with the property. Property will remain there. I am only limited. My lord, kindly modify.
Learned counsel. So you are specifically, you are prejudiced by the order of restraining construction.
My lord. I am not constructing, it is two-story
Construction,
repairing.
whatever, single story or
No, two-story, it is two-story, I purchased two-story.
whether it is construction and repairing,
Different
two
thing.
separate parts.
Yeah, my lord, my lord.
And as regards to repairing, it has to be sought for before the court in session, that is the trial court, whichever the trial court may be, civil judge junior division or civil judge senior division, whichever. But the suit for declaration, civil judge senior junior division, obviously it will be civil judge junior division.
My lord, your lordship's hands are long. My lord, I am, my lord, praying
Nothing.
within my periphery of order impune, my lord. My lord, being aggrieved by the order of injunction, I approached the learned appellate court. My learned appellate court since refused my prayer. For that reason, my lord, I have to come before your lordships. My lord, my lord, say, my lord, first thing is whether I have any merit, whether the suit is at all maintainable.
No, no,
This document is sufficient. And my lord, in my written statement also, my lord, now I am not admitted the genealogical table.
What you have just now submitted,
Yes.
if you are prejudiced to that extent only,
Only. You
Then-
have to kindly grant relief to that extent. To that extent, only repairing.
no,
my
this
job-
court don't, this court don't. You will have to obtain
My lord, may I come
before
tomorrow,
the-
my lord?
known.
So because my lord,
No.
tomorrow morning, first I take
No, no.
number one, my lord, because my lord, in court, no,
Achha.
my lord,
That is, that you say.
my
I
lord,
thought,
some pension matters, my lord, that
I
is
thought,
urgently, my lord.
I thought something.
Yes, my lord, tomorrow, my lord,
district
item
submitted.
number one, my lord, because my learned friend will also submit something, my lord. For that
Yes,
reason,
obviously he will
your
get the
lordship
opportunity.
relieve me today, my lord. I am coming
Not
at
something,
10:30.
anything.
Many things. So today, my lord, kindly, tomorrow, kindly
Your
fix.
submission is left to be, more to be submitted. Something
no.
is left.
No. I have to follow their submission.
Huh?
I have to answer their submission, and I have to satisfy your lordships. If your lordships can,
No, as far as
if
I
your
could get, as far as this court could get from your submission, is that you are prejudiced by that portion, that is
yes.
restraining
I need
construction.
modification only that extent.
And your contention is that you want to repair. Repairing and construction,
Different
separate
thing.
and as regards to repairing, you will have to seek permission from the
Your
trial
lordships,
court.
your lordships can modify it, my lord. It is not beyond your
Sir,
lordship.
this kind of prayer has been made by my learned friend's client in the trial court or not? No.
ঠিক আছে, কালকে-
By
কালকে
filing
আজকে-
written objection, there were a very larger scope for my learned friend to point it out. No, I am not constructing, but so far as the construction is repairing of the property is concerned, I am also objecting that because he has acquired
That is
entire property.
Learned counsel, that is separate issue.
Yes,
Repairing is separate issue that he will have to, the
yes.
plaintiffs, the defendants will have to bring before the trial court. Prima facie, this is the view.
tomorrow, my lord.
Neil.
না সারাদিন ধরার দরকার নেই, ব্যবসায় অনেক কাজ আছে।
There won't be any assurance as regards to that the matter will appear at the top of the list.
My learned friend is trying to conduct a mini trial.
No.
Because this is arising out of civil division, arising out of injunction order. And he is now
When
showing plaint and other things
when
that was to
there-
be decided.
when there is an order in
documents
this appeal, it will.
Those documents has not been neither been produced by them in
what
in
my
proper
learned
form. That is to be exhibited. Everything is remain.
When
Whether this can be
the
shown to
impugn
this-
order from a miss appeal, it is equivalent to second appeal hearing, generally. But I, my lord, concise my prayer, my lord, that what prejudiced me at this juncture, and what was their prayer, what was their intention by filing a suit for partition, wherein, my lord, local club was also made party.
Learned counsel,
My lord, tomorrow, I am, my lord,
I'm restraining myself.
I am, my prayer is tomorrow kindly keep the matter at the top. my lord.
And then, the learned counsel representing the revisionist petitioner. Petitioner or petitioners?
Petitioners. Two.
Two.
are there. Myself and my wife is a purchaser.
Only one, my lord, petitioner.
The learned counsel representing the petitioner submits at length as regards to submits at length, but but does not conclude. But does not conclude. Full stop. He further submits. He seeks an accommodation for this day for further submission. আগামীকাল কি কোনো আছে কোনো আইটেম টপে আছে আগামীকাল আছে হ্যাঁ ও তাহলে এটা আইটেম নাম্বার 2 হবে ঠিক আছে না না মানে টপে একটা আছে বুঝতে পারছি সেকেন্ডে কিছু আছে 2 এতে কিছু আছে কোনটা ও আচ্ছা 2000 আচ্ছা আচ্ছা তাহলে এটা আইটেম নাম্বার 3 তে করে দেবেন ঠিক আছে এটা আইটেম নাম্বার 3 কি হলো does not conclude accommodation for this day full stop prayer is allowed let the matter appear on tomorrow হচ্ছে 12th of August as item number 3 it will appear নামগুলো নিয়ে নিতে হবে নিয়ে নিয়েছেন তো next talk it has not been called learned counsel as yet it has not been called
Number 7, madam, for the defendant opposite party number 1.
Your Lordship, I appear on behalf of the petitioner. The learned counsel, Mr. Kushal Chatterjee, was appearing in this matter. He is not present today. So I humbly pray before your Lordship to kindly take it forward.
He is not present today, but in the first half he is there. Right now he is not here.
had he been in court
So
at present he is not in the court had he been here
In first half he is there. He was in court. But
he left because of some family emergency.
when can the matter be taken up not today
tomorrow.
no order is being recorded
Madam.
tomorrow it will appear
Madam.
no adjournment will be granted tomorrow order note নিয়ে নিন order নিয়ে নিন order ওনাদের নাম নিয়ে নিন order করে দিন learned advocate representing the petitioner seeks an accommodation for this day are you the advocate on record the learned advocate representing the petitioner seeks an accommodation for this day full stop considered allowed let the matter appear on 12th of August next
Number 8. And I beg to appear for the opposite party number 1. I'm paying for not to then. Or only one.
are you the advocate on record you are the advocate on record you start
I have no.
you start
I have no.
you are the advocate on record you start learned counsel that is not a reason being an advocate on record you must have the brief in your possession you start learned counsel
Ask for adjournment.
let the matter go out of the list
mentioned you were writing you writing he mentioned
Okay, that one, which
that
one,
my
which was
junior was there. Only
Acha.
one thing, my lord, may I just indicate.
But learned counsel, being an advocate on record,
I am extremely sorry, Lordship.
you cannot say that I am not possessing the brief.
I am extremely sorry, Lordship.
Yes, Mr. Banerjee.
Only one thing, my lord. I'm not opposing my learned senior friend, but what has happened, my lord, I beg to appear for the opposite party number 1.
Only one.
Yes. The service.
Item number 8.
Yes. My lord, on the earlier occasion,
8,
there was a direction by the coordinate bench to serve.
Mm.
My client was not present and service has not been affected,
Mm.
but from the trial court, I came to know of this number.
Mm.
Now let them serve a copy of the civil divisional application upon it. The service has not been affected by my learned. There was a direction by my Lord Justice Bhattacharya to serve.
So,
They had sent.
you are representing only Anjan Maiti.
Oh, I represent only Anjan Mai.
Who is Robin Kumar Chakraborty?
And I don't know.
As regards to Robin Kumar Chakraborty, has it been served?
Lordship, the record is not with me, Lordship. Kindly make it not with me. Kindly, Lordship.
How can you say this? How can you submit before a court?
Not bring the big.
It is most unfortunate. Nothing more to be said from this end, but it is most unfortunate. Being an advocate on record, you are saying that you do not know.
Extremely sorry, Lordship.
The dispute involves, Mr. Banerjee,
My Lord,
a block land and land reforms officer has been made a party.
yes.
He is the opposite party number 3.
Civil suit is a civil suit, and my Lord,
Declaration.
written statement.
The suit for declaration.
Yes, my Lord.
Oh,
Suit for- by dint of the order impugned, my Lord.
Directed to maintain against the temporary injunction.
No, by dint of the order impugned, my Lord, I was directed to file the written statement, my Lord, subject to correction, my Lord.
Mm. The last order is dated, order number 12, dated 31st of January 2025. Order number 13. Order being agreed by the order number 13. Where is the order number 13?
Order number 13.
Order
dated
number 13. 13th of March
2025 he has come up.
See, you have provided the first page contains order number 1. Second page contains the same order of the same date. Thereafter, the third page contains the impugned order. That is the order number 13.
13.
And the fourth page contains order number 10, 11, and 12. So they have preferred this to this fix for hearing a petition under section 151 CPC.
That petition was probably filed by my client.
The rival submissions of both sides and perusal of the rulings relied on by the defendant side. This court is in accord with the submission of the learned advocate for the defendant side, and according to the petition filed under 151 CPC, praying for passing an order of rejection, cancellation of the written statement and written objection of defendant number 1, and also praying for hearing of this suit ex parte against defendant number 1 stands rejected by this court. Learned counsel, this matter will be taken up on which date? Positively. Day after tomorrow. Positively. On that day, you will have to make an alternative arrangement, or you will have to submit.
Let them serve a copy of the civil petition.
He is not in possession of the brief.
And let him serve tomorrow, my lord. Kindly records that. Kindly records that. He will serve.
ওনার নাম নেবেন learned advocate
Act number.
learned advocate representing the petitioners seeks an accommodation for 2 days on the ground of a senior full stop considered and allowed full stop let the matter appear on 14th Friday 14th of August 2026 full stop.
Get fully.
So
And let him serve. My lord will kindly record service.
you are the defendant number 1.
Opposite
Because
party
the
number
trial court.
one.
No, the
Anjan Maiti is my client.
let me go through the plain
Yes.
if it has been provided.
Anjan Maiti happens to be the defendant number 1.
Anjan Maiti happens to be the defendant number 1.
One.
So they had sought for the relief in respect of Anjan Maiti only.
Yes. Suit for declaration.
Yes. Yes. They had sought for proceeding with the suit ex parte against defendant number 1.
Yes, ma'am.
That prayer has been rejected. Come prepared and no. Even at this stage, the learned counsel representing the opposite party number 1, namely Anjan Maiti, submits that copy of the civil revision application has not been provided. Full stop. In such circumstance, the learned counsel representing the petitioner is directed to serve a copy of the application, civil revision application, to the learned counsel representing the opposite party number 1 by tomorrow. That is date ta diye deben by 12th, by 12th of August.
Get to the yellow.
নামগুলো নিয়ে নেবেন। Next.
All this while matter was urgent.
Yeah. These things are to be noted.
It's my first week, there will be some difficulty, but next week onwards, I hope everyone.
But at least somebody should be
Yes.
there to represent. কি বলে শুনুন, আপনি ডাকুন, বুঝেছেন, এই 83 অব্দি ডাকুন, 83 অব্দি ডাকুন, ডেকে যান, একটা একটা করে ডাকুন, সেকেন্ড কলে অর্ডার হবে। In spite of second call, none appears on behalf of the parties. Full stop. Next line. For the ends of justice, let the matter appear on নয় থেকে বুঝতে পারছি সব ওল্ড ম্যাটার 9 থেকে 83 তার মানে 10 থেকে ধরি 11 থেকে যদি ধরি 70টা মতো 70 72 73 রকম হবে 74টা হতে পারে 10টা করে এক এক দিন রাখুন বুঝেছেন মানে ফার্স্ট ধরুন এখানে 1 উইক থাক let the matter appear on 17th of August ঠিক আছে প্রথম 10টা আপনি করুন তারপরের 10টা মানে ওই ভাগ করে নেবেন ঠিক আছে তাহলে 9 হলো আইটেম নাম্বার 10 রাখুন same order in spite of second call none appears on behalf of the parties for the end of justice let the matter appear on 17th of August next same order রাখুন same order 17 হবে মানে 10টা 17 হবে, তারপরে 11 নম্বর থেকে 18th অগস্ট হবে, 11 থেকে 20, তারপরে 10টা পার ডে 10টা করে। হুম, হ্যাঁ, 17, 18, 19, 20, 21, তারপরে দেখুন নেক্সট সেম অর্ডার। নেক্সট আইটেম নাম্বার 14 সেম অর্ডার। আইটেম নাম্বার 15 করে দিন, সেম অর্ডার। সেম অর্ডার। সেম অর্ডার। সেম অর্ডার। 18, 18 তো দেখানোই হলো না। 18 দেখান, 18 সেম অর্ডার। নেক্সট সেম অর্ডার। 19 অবধি, 17 তারিখ থাক, ঠিক আছে। 20 থেকে 18 করে দিন, আপনারা আপনার মধ্যে ভাগ করে নেবেন। এবার নেক্সট এখন 20। কালকে যে আরেকজন ছিলেন মিস্টার আলী, আইটেম নাম্বার 20 হলো। নেক্সট সেম অর্ডার। সেম অর্ডার। সেম অর্ডার। সেম। সেম অর্ডার। সেম। নেক্সট সেম অর্ডার। নেক্সট সেম অর্ডার। সেম অর্ডার। 29 অবধি হয়ে গেল। নেক্সট ডেটটা 18th হলো, 30 থেকে 19th হবে। নেক্সট সেম অর্ডার। নেক্সট সেম অর্ডার। সেম অর্ডার। না, 32 দেখানো হয়নি, দাঁড়ান। হ্যাঁ, 32 সেম অর্ডার। সেম অর্ডার। সেম অর্ডার। সেম। সেম with 38. Same order. Same order. এত দূর পর্যন্ত আর একটা ডেট হলো, এটা কত হলো? 19th হয়ে গেল। এবার 20th হবে। নেক্সট সেম অর্ডার। সেম অর্ডার। সেম। সেম। সেম অর্ডার। সেম অর্ডার। সেম। টাইপ করুন না, কালকের মধ্যে আপলোড করলেই তো হলো, ঠিক আছে? কিন্তু ওই হবে তো, কি বলে, শুধু তো না, কি এমনি করলে হবে, কি হবে? হ্যাঁ, কস্ট রাইটিংটা দিতে হবে, কেলেন ওই কেলেন সব কিছু দিতে হবে তো, শুধু ওই অর্ডারটা হবে না, পার্টির নাম দিতে হবে না, পার্টির নাম দিতে হবে, বিশেষ করুন না, ডেট তো আছে, কি বলে 17 থেকে আরম্ভ হচ্ছে, করুন না তাহলে, আজকাল করুন। নেক্সট, সেম অর্ডার, নেক্সট, সেম অর্ডার, সেম অর্ডার, সেম অর্ডার, সেম অর্ডার, নেক্সট, সেম অর্ডার, সেম, সেম, সেম অর্ডার, সেম অর্ডার, সেম অর্ডার, সেম অর্ডার, সেম অর্ডার, 61 থেকে আরেকটা 22 শনিবার, তাহলে 24th আগস্ট, কত 61 24th আগস্ট, সেম অর্ডার, আচ্ছা, তাহলে 60 থেকে নেক্সট, সেম অর্ডার, নেক্সট, নেক্সট, সেম অর্ডার, সেম অর্ডার, সেম, সেম অর্ডার, সেম, সেম অর্ডার, সেম অর্ডার, সেম, 70 চেঞ্জ হলো, ডেট চেঞ্জ হচ্ছে, 70 71, সেম অর্ডার, নেক্সট, সেম অর্ডার, সেম অর্ডার, সেম, সেম, সেম অর্ডার, সেম অর্ডার, সেম, সেম, সেম অর্ডার, সেম, 80 থেকে 26 হচ্ছে, ঠিক আছে, সেম, সেম অর্ডার, সেম, ধীরে ধীরে করুন, নিন এবার ডাকুন, 83 ডাকুন, ওটা কি বলে, তাহলে একবার তো আসছেন বিকেলে, আপনার একবার নিয়ে আসতে বলবেন। মানে এগুলো না যা ঠিকঠাক চেম্বার নিন। 83 ডাকুন, না 84।
84 in this matter, I am appearing for the opposite parties, my lord. At first, I am submitting to your lordship that 84. In this
Second appeal,
my lord, this
you
matter
are
will,
the respondent.
I am for the respondents, my lord. This matter will come under the heading hearing, my lord, not application, my lord.
No,
As because application has already been disposed of,
all the applications have been
disposed of, my lord. If your lordships kindly come, the paper book, page 38, I have filed also paper book.
Let the file be handed over. So can 1 of 2010, that is under order 41 rule 27,
My lord,
additional evidence.
by challenging the order of the title appeal, file this second appeal before your lordships by the applicant, plaintiffs or appellants.
Essay হচ্ছে 268 of 2013. Learned counsel, learned counsel, learned counsel. When a matter has been called, it is over. Order has been passed. You will go through the order, uploaded in the server. Which item are you representing in which 76? It was called. After the second call, order has been passed. For the respective party, having considered the statements made in the application, the delay in planning the appeal is condoned. It is believed that such delay has been sufficient to explain. On three substantial questions of law.
My lord.
Framed on 1st of August 2014. The application which is appearing, that is old can number 9639 of 2010. The application for stay of all further proceedings.
My lord.
So at this present juncture, apart from hearing, nothing left. Paper books
I have filed, my lord. I have filed the department.
In the department, requisite number of paper books have been filed.
My lord, requisite number of paper book I have filed before the department. On 19th March 2026.
19th
March 2026. My lord.
19th March or 9th of July 2026. There's
I have,
there is a report dated 9th of July 2026.
but
Two copies.
2 copies, my
Two
lord.
copies of
2
paper book.
copies,
Yes, yes, yes. 2 copies of paper book filed on 19th March 2026.
my lord.
This is the order. Yes. So it is otherwise ready.
My lord, what happened? Mr. Sukhant Das is engaged by my client as senior, my lord.
Hmm.
So today I have come with your lordships, the under heading appearing application, but it will
It
come
will appear
under
under the hearing.
hearing,
The
my
heading
lord.
hearing only.
And fixed
not
any
under
date,
this application.
my lord. Any day.
What about the appellants?
Appellants by challenging the order dated 16th 3rd 2010 in appeal 22 2008, my lord. Preferred the second appeal before this honorable court, my lord.
Nil. When it can be fixed?
My lord.
Let it appear day after tomorrow.
August.
Let the matter appear
13th.
on 13th.
My lord, 13th, another matter has been fixed. So if your lordships kindly 18th is possible, my lord. 18th August.
18th. Nil. None is representing the appellants. Full stop. Next. The learned counsel representing the respondents. You are representing all the respondents.
Respondents, my lord.
Representing the respondents.
Although respondents 2 expired, my lord. That application also filed and that has already been disposed of.
Are the legal heirs already on record?
Only, my lord. Gobindo Ghosh.
Govindo Ghosh is the respondent number 1.
My lord. And his
But-
wife was the respondent number 2. But his wife has already been expired.
Already expired.
My lord.
They do not have any son or daughter.
No, son and daughter, my lord, they have. But that application has also been disposed of.
No, she has not been substituted.
Substitution application has already been disposed of, my lord. But
So if it is disposed of, if there is any legal heir,
my lord,
then he or she will have to be substituted.
yes, my lord. But I have, as because this is change brief, my lord.
So which application substitution was fought for? Otherwise, there will be order against the dead person.
My lord.
There is no other app. There is no application being found in. Yes. When did she expire? No, there is only one application. That is application under Section 5 of the Limitation Act. That has already been disposed of. And there is another application
My lord,
That is
Savitri
for state.
Ghosh, Savitri Ghosh expired 3rd June 2025. 3rd June 2020,
3rd
15,
June
2015.
2015.
My lord. 3rd June 2015, my lord. Savitri Ghosh was the respondent number 2.
When the judgment of the first appellate court has been passed. No, it has been passed on 10th of March. Sorry, 16th of March 2000.
March
16th of March 2010.
My lord. In titles,
Senate Council, in the record, I am unable to find any application. And
application for
substitution,
substitution, my lord,
substitution.
of substitution. I am
And the last order of the court has been passed on 1st of August 2014, wherein 3 substantial questions of law have been framed.
then when fixed another date, my lord. This is trouble to me. Change brief.
The Learned Council representing the. You have the death certificate?
Death certificate, Xerox death certificate, my lord.
Never mind.
Yes.
So, no, not required to. Herein, the name is Savitri Bala Rajbanshi.
My lord. That is after
Her maiden
marriage,
name.
Savitri Ghosh.
Savitri Ghosh. She was wife of Govinda Ghosh.
Govinda, wife of Govinda Ghosh.
The Learned Council. Last sentence কি হলো? No, respondents হবে না. The Learned Council representing the respondent number 1 submits that the respondent number 2, namely Savitri Bala Ghosh, who has been stated as Savitri Bala Ghosh, wife of Govinda Ghosh, that is the respondent number 1, who has been stated as Savitri Bala Rajbanshi, R-A-J-B-A-N-S-H-I, Rajbanshi. Savitri, S-A-B-I-T-R-Y. S-A-B-I-T-R-Y. Memo? Memo. Savitri, S-A-B-I-T-R-Y, Savitri Bala Rajbanshi, R-A-J-B-A-N-S-I-S-H-I. Banshi has expired on
3rd June 2015, my lord.
3rd June 2015. Full stop. Paragraph. On going through the record, no application seeking substitution of the said Savitri Bala Rajbanshi, wife of Govinda Ghosh, Savitri Bala Rajbanshi লিখে না ব্র্যাকেটে রেসপন্ডেন্ট নাম্বার 2 করে দেবেন। Respondent number 2, wife of Govinda Ghosh, is not found. ঠিক আছে, is not found. Full stop. Paragraph. As none is representing the appellants বলেছি as no no as none is representing the appellants, as none is representing the appellants, the matter cannot be proceeded, full stop. In such circumstance, let the matter appear on which date?
My lord, 18th
18th
August.
18th of August 2026.
6.
Under the heading
Here.
now because until and unless substituted, do you have legal heir?
I have
Do you have any son or
yes,
daughter?
that son, my lord.
So the
Son,
he is to be substituted.
but within 18th. Kindly,
If
yes,
you intend,
I inform.
if you intend to have the matter disposed of, then inform the
Inform. I will
counsel
inform to the
representing the appellants.
my lord.
The trial court decreed.
Trial court.
First appellate court affirmed. Against affirmation, they have come up. That's why not interested. Next. It will be taken up. Serve a notice. There won't be any direction. Serve a notice.
Notice to the appellant.
Counsel representing the appellants.
Appellant. Yes, yes, ma'am. না দিইনি, দিচ্ছি।
Next. Number 85. দেখুন 86 88 অবধি রাখুন 88 অবধি রাখুন item number 86 item number 87 item number 88 সেকেন্ড কল করুন 80 ওই 85 থেকে 84 এর অর্ডার হলো তো 85 সেকেন্ড কল করুন item number 85 নিন সেম অর্ডার হলো না ওই যে 9 থেকে ওখান অব্দি ওইগুলো ধীরে ধীরে করুন বুঝছেন ওগুলো তো সময় আছে ওগুলো 2-3 দিনে মানে কাল পরশুর মধ্যে ওগুলো আপলোড হলে হবে এই অর্ডারগুলো করে দেবেন আগে 85 নালে ফাইলটা none is representing either the petitioner none is representing either the petitioner or the service আগে ঢুকিয়ে দিয়েছে none is representing either the petitioner or the opposite party. In such circumstance, the matter cannot be proceeded. Let the matter appear on 17th of August. Full stop. On the earlier occasions, on the earlier occasions, on the earlier occasion, that is on 31st of July 2026, none had represented the parties. Full stop. তারপরে let the matter appear on it.
Item number 86.
ওখানে বসেই নিন, ওখানে বসেই নিন। None is representing either the petitioner or the opposite party. Let the matter appear on 17th.
Item number 87.
87 কি অফিস রিপোর্ট কি আছে? অফিস রিপোর্ট The Honorable Court's order dated 24/2025 may kindly be perused. In terms of the Honorable Court's order dated 24/2025, it is humbly submitted that in respect of the defect regarding point number 1 mentioned in previous office report dated 2025, flag A. Flag A, learned advocate for the appellants has not yet turned up before the department to incorporate the names of the substituted appellant, numbers 1A to 1C of the learned first appellate court in the cause title of the instant memo of appeal. As regards the defects on the point numbers 2 and 3, the certified copies of both the decrees annexed herewith needs to be sent back to the learned first appellate court for necessary rectifications. Thereafter, the cause title of the instant memo of appeal may also be rectified with the learned on record. In terms of the rectified decree, once the same is received back from the learned first appellate court. Under the circumstances, the matter is not placed to the Honorable Court for favor. Name. None is representing either the none is representing কত 87 এটা 86 টা নিয়েছেন তো আগে 86 টা নিয়েছেন তো none is representing the parties in such a situation. The matter cannot be proceeded. Let the matter appear on I'll get date দিয়ে দিন 12th of August. Next.
Item number 88.
Same order 87 এর মতো আগামীকাল থাকছে আগামীকাল সেম অর্ডার
Number 89.
দেখুন
Item number 90.
next
Item number 91.
next
Item number 92. Item number 93. Item number 94.
next
Item number 95.
What are you, let's kindly take up this tomorrow? Tomorrow,
item number
95.
95
Lordship, I'm seeking one intelligence, Lordship. I preferred one can application can 9 of 2026, Lordship, for addition of party. Lordship.
There are few applications
Lordship.
remaining to be disposed of.
Lordship.
Can 1 of 2004?
Lordship, as I'm not party here till now, Lordship, I can't.
We intend to be added as a party.
Lordship. As because
Who is there for the appellants?
I'm for the applicant.
You're for the appellants. How many applications are pending?
Probably 4 or 5 applications, my lord.
Can 1 of 2004 disposed of?
No more than that, not even. One of 2004, that has been disposed of. That's the injunction order was it, that. Second time still.
Can 2 of 2010
That is pending.
pending? Can 4 of 2012?
That is also pending.
Can
But I mentioned this matter several occasions before the Divan Court's matter. The matter was not appeared. Ultimately, it was appeared in the 752.
let us forget the past.
His Lordship was pleased to direct the landed court bureau to produce the records. That is their last order. You Lordship kindly see the records. Last order.
The order book to this.
Last order is there. So my remember it. I remember.
None appears on behalf of the respondent. It appears from the report submitted by the department that although the trial court record in connection with this appeal, being title appeal 140 of 2001 and title suit 34 of 1991 were received from the learned trial court, but the said trial court record could not be traced out during physical verification. The trial court record is not traceable.
Yes, that is the main problem, my lord. Last order is there, my lord. After that, my lord, report is there, my lord.
Nil. In compliance with the above-mentioned solemn order of the Honorable Court, it is most humbly submitted that the department has applied full effort to trace out the connected trial court record of the instant appeal. The department has searched out old record room at ground floor of the 6th floor in the building, as well as searched the new record room, which arranged after shifting the department 4th floor B block of new secretary building. Department has not been able to discover the same till now. In process of the missing TCR is still going on. And I sincerely apologize for not placing the connected TCR. Still now not traceable.
That is the main problem. Otherwise, my lord, I will find my paper file out of time, out of court, my lord, paper, my lord, taken up. But I also filed an application for injunction, my lord. That is still pending. Few persons are trying to disperse me, my lord, on that ground, my lord, I filed an application for injunction.
Second appeal just filed in the year 2004. On perusal of the order book, it transpires that a report has been filed dated 23rd of March 2026 from which wherein it is mentioned that the trial court record has not been able to be searched out. Full stop. In such circumstance, the department is directed to search out the trial court record and file a report within. Let the report be filed within 28th of August. Let the report be filed within 28th of August. Full stop. Let the matter appear on 28th.
Yes. Lordship, seeking one indulgence, Lordship. In Can 9, Lordship, I preferred as addition of party, Lordship. In the meantime, I will serve to my learned senior friend. Lordship, that is also considered to be on that date, Lordship.
Unless and until the trial court record is searched out, traced out, we cannot proceed.
Lordship, my application is required to be heard, Lordship. Otherwise,
Without the stem, the branches will take place.
I understand.
Let
This
the-
is third party, my lord.
Let the trial court record be traced.
Lordship.
তুমি তো জানো আমার নামটা
Next.
প্রশান্ত কুমার ব্যানার্জি
Great.
Lord, in this matter, I appear to the application. It's an application for restoration along with section 5 application. It's a preemption matter.
Section 5 in respect of the second civil revision.
Section 5 in connection with the application for restoration.
Restoration.
Yes. There was a delay of 3,295 days.
Only.
Yes. So preemption matter, my lord. Initially, the revision and application was admitted. The status quo order was subsisting.
Has it been served upon the other side?
Lord, I have served, but since no one appearing, Lord, kindly fix a date, direct me to serve.
PO 1282.
বাইশে কোড নম্বর 22 ফাইল হয়েছিল।
Can 1 or can 2? Can 2 or can 3?
কেন আমি তো নেই কিছু।
No.
Section 5 application.
Section 5, my lord, can 3.
It is not in the record.
Lord, this is the application, my lord, if your lordship kindly have a book.
Unless and until, let it be with you. Let it be
Man,
with you.
man.
Let it be with you. আমাকে দিয়ে লাভ নেই।
Right, going as can is appearing.
Can 3 of 2025. এই ক্যানটা ট্রেস আউট করুন, বুঝলেন? Can 2 of 2025.
Application for restoration.
That is also not in the record. There is only one application, old one.
Old one.
No, Can 2 is of 2025 and Can 3 is of 2025. This Can is of old
3, both are of 2020.
7005 Can number 7005 of 2006. Apart from that, through which you had sought for appropriate order.
My lord.
Apart from that, there is no other application in the record.
The current applications have been filed in 2025.
There's 25.
Lord,
As
let those
it
be
reveals from the cause list. Nin. Nin.
it's shown in the list that the applications are appearing.
শুনুন ওই কোথায় কোথায় ফাইল করেছেন না করেছেন সেগুলো দেখে নেবেন, দেখে নিন। Let the applications be traced out. Thereafter, there will be direction to serve upon the learned counsel.
As your lordship, I don't have any objection.
But in the meantime, also you can
let it remain in the list.
It will remain in the list. In the meantime, you can serve upon the learned counsel representing the opposite party or party.
Very difficult because the possession has been taken away. No one is traceable at present. Only the party upon the party, otherwise it cannot be.
What has been taken away?
Not the possession, preemption application.
Oh, the possession has been
satisfied. Yes.
Satisfied. The petitioners are being represented, but none is representing the opposite parties. Full stop. On perusal of the record, on perusal of the record, neither the application being Can 2 of 2025, through which restoration has been sought for. 2 of 2025?
Minor.
Through which restoration of the said revisional application has been sought for. Can 2 of 2025, through which neither the application being Can 2 of 2025, through which restoration has been sought for, nor the application being Can 3 of 2025, through which delay is sought to have been condoned, are traceable. Full stop. কাকে ডাইরেকশন দেবো আপনাকে না ডিপার্টমেন্টকে? Department is directed to trace both the applications being Can 2 of 2025 and Can 3 of 2025, and to tag with this file. Let full stop. In the meantime, learned counsel representing the petitioners is at liberty to serve the copy of
the service was effected once. Let me communicate the order itself.
Which order?
Since my lord is passing an order.
You served, this is of 2000, civil revision is of 2006.
Yes.
You served the revisional application, including the Can applications, both the Can applications upon the opposite parties.
They have accepted.
That is about, I think, 15 years ago.
No.
Not
after filing this application.
Yes.
This application.
Which application?
Can to both these cans.
Serve it once again.
Very well.
Serve afresh.
I serve. 4th of December 2025 was served.
Serve it, huh? In the meantime, the learned counsel representing the petitioner is at liberty to serve the copy of the revisional application along with both the applications seeking restoration and condonation of delay upon the opposite parties. Let the matter appear.
Not opposite party number 1 and 2.
Opposite parties.
They are the preemptors only.
How many opposite parties are there?
There are several opposite parties. Since one of the deceased
persons, not the preemptors are
No,
two. 1 and 2.
You have mentioned 1 and 2 only. One is Sheikh Ajijul
Jijul
and the other is minor
minor Sheikh
Sheikh
Fajlu.
Fajlu. Apart from them, nobody else has been mentioned.
Very well, my lord, I shall serve that.
Opposite parties. Last sentence ki holo? Serve korte bolam. Let the matter appear on 28th of August. 28.
My lord, grateful to your lords. नाम लिखे दीजिए ना
My lord, in this matter, my lord, it is almost similar and identical to what your lordships has passed an order right now. It is also that
How many applications are there?
three applications are there. My lord, one is
One of 25, 2 of 25, 3 of
My lord,
25.
My lord, I was been led by Mr. Rajesh Shah. I am praying for now.
Let him submit.
My lord, Mr. Shah has also told me to follow to me.
Oh, sir, it's okay, sir. You are senior to me.
Learned counsel, don't leave your space.
My lord, actually, the Shah, he's on behalf of the petitioners. And
What
he
is
has-
the fact? All the three applications are untraceable.
No, I believe they are traceable, my lord.
So,
Because in
so
2025
not similar to the earlier one.
I
In the earlier one, both the applications were not traceable.
But here, I need to say, my lord, one is the condonation of delay, restoration, and the setting aside, my lord, of abatement and the substitution.
Condonation of delay.
Yes, my lord, there is
Of
there-
only how many days?
As a long delay, my lord, is there, and I have been led by Mr. Shopun Nundi in this matter.
When asked for how many days delay, you are stating I am being led by. This one is restoration. This one is application for substitution. 1 of 25 is restoration. 2 of 25 is substitution. Who has expired?
Kanhaiya Shah, the petitioner.
Sole.
Yes, my lord, he was the sole petitioner. That is the,
So that will have to be taken up first.
and my lord, as per your lordship,
1 minute, 1 minute.
your direction,
Oh, 1,268 days delay only.
and my lord,
Hmm.
I was only submitting one thing, my lord. As per your lordship's earlier direction, we have served upon the copy of all the applications upon the opposite parties. And your lordship was also pleased to direct us to serve about the intimating that the matter would be taken up, that the matter is running in the list, or before your lordships, also before the learned advocate who was representing them, before the learned court below. My lord, we all have, everything has been done, my lord.
You are representing whom?
My lord, I was only representing the same side, my lord, as because Mr. Rajesh Shah.
May I submit one thing, my lord?
No. What are you submitting?
My lord,
Whom you are representing?
my lord, I am also representing the plaintiff here, as I was.
Petitioner.
My lord,
Petitioner.
My lord, I was actually led by Mr. Rajesh Shah to take note today.
my lord, may I see-
Whom is he representing?
my
The
lord,
opposite parties.
No,
No,
not
my
at
lord,
all,
same side.
not at all. Mr. Shah has also told me, and he has also told him. And that is the difficulty. I was-
Double effect.
Double effect. Sorry. Your lordship. That is why I was saying.
I thought he is representing the opposite parties,
My lord, even-
seeking accommodation.
No, my lord, I was only saying, my lord, Mr. Shopon Nundi is leading us in this
Yes.
matter, my lord. Kindly, my lord, kindly keep this matter in the coming week, my lord, so that he can be here to assist your lordships, my lord.
What is Mr. Nondi doing during this week? The remaining days of this week?
My lord,
12th, 13th, 14th?
I had contacted him. He said that he will be going through the briefs and getting prepared and other things. He said that. It's kindly keeps it
But,
my lord. Your lordship,
first of all,
whatever your lordship desires, my lord.
can you, give your name. Your name only. Learned advocate representing the oh. The petitioner মারা গেছে. Whom are you representing now?
The substituted, all of them.
Not substituted.
But not yet, my lord. The
intending
to be substituted, my lord. I stand corrected. Grateful, my lord.
The learned advocate representing the petitioners, intending to be substituted as petitioners, seeks an accommodation on behalf of the seeks an accommodation on the ground of his senior. Seeks an accommodation for a week. Seeks an accommodation for a week on seeks an accommodation for this week. On the ground of a senior. Full stop. Considered allowed. Let the matter appear on
18th or 19th.
Let the matter appear on 18th of August.
And I'm so grateful, my lord.
Request mission only to be to come prepared on 18th. Next.
So great.
Much next. Mr. Pachal, how many applications are pending?
2 applications, not restoration.
2. But the cause list is revealing several applications. 98 and 99.
But the application, since it is not, I have been engaged in this case, can 11840 and 11827. 846 and 827. 2 applications in I am possessing now. That is, one is restoration application and a delay.
Can 99? Old number, can 99? In 98, there are 2 applications. Can 3 of 2019? Can 4 of 2019? In 99, there are 1, 2, 3, 4, 5, 6. 6 applications pending in 99. In 98, 2 applications. In
I don't
99,
have the correct information in this regard. I will come back with this detailed information. I was simply thinking that the restoration application, which was filed there was little delay in filing the application. That's why these 2 applications would be hard out. But then the junior is not here, who is involved in this matter.
Not today.
Let it be not today and tomorrow, day after tomorrow.
Not today. Order দরকার নেই, অনেক order হয়ে গেছে. Not today.
Okay.
Altogether, there are seems to be 8 applications pending. Item number 98 and 99. Next.
Day after tomorrow.
It is no order is being passed, so it is being kept tomorrow. May be taken up or may not be taken up.
Okay.
There is hearing continuing. Next. Next.
Item number 101.
Next.
102.
Well, in this matter, I am for the opposite party, my lord, respondent. What happened, my lord? One application, substitution application already allowed by the Honorable Justice S.K. Prasad on 17/7/2019. And another application is an injunction order, injunction application that is pending.
Sir, I've got the,
No matter my prayer is
In which matter?
the 102.
102.
My lord, I'm praying.
that is my prayer is, my lord.
Take your breath.
If the paper book has come, my lord, they have already prepared the paper book, my lord. I have already received.
There are, cause list reveals two applications.
Yes.
Can 1 of 2001.
One
Two
is the
can 1 of
substitution.
substitution.
Substitution already allowed. One is stay petition and
Stay, at this juncture, let it be taken up with the hearing. Can
substitution already allowed.
Can 2, sorry, can 4 of 2012
Substitution application.
substitution.
That has been allowed.
That has been allowed.
Yes.
Disposed of.
Yes. On 17/7/2019. They have already filed a paper book, my lord. That is, I have already received.
So, according to you,
Yes.
it is otherwise ready.
Yes, my lord. You
for
should
hearing.
fix up the matter any day.
Yes, Learned Counsel, any submission?
My lord, I'm for the petitioner. My lord, I'm being led by Mr. Pratip Kumar Chatterjee, learned senior.
For the appellant,
for the
appellant or appellants, whatever.
appellants. My
Appellant,
lord,
appellant.
my lord may fix the matter any by next week, my lord. Any day.
No.
As per your lordship's convenience.
If my lord, lower court record has come, my lord, then only you will proceed the matter, my lord.
Obviously, the trial court record and the first appellate court record has arrived. Otherwise, how could they prepare the paper book?
No, my lord, paper, my lord, second appeal, my lord, paper book, my lord, trial court is not necessary because my lord,
In second appeal, the paper book is not necessary.
No. Trial court record is not necessary. Only paper book, my lord, prepared by both the court judgment and
Paper book is required. You can say that the plain written statement all are not
my
required
prayer is,
to be
my lord. So my prayer is, my lord, if the court below judgment and
court is now concerned whether any other application is pending.
Yes.
দেখুন তো ওখানে কোনো অ্যাপ্লিকেশন আছে কত 102 না 102 তে একটা দেখুন বার করুন তো can 3751 of 2001 can 3751 of 2001
can 37
both the sides are willing to have it disposed.
Yes. This substitution has been disposed of.
No. The second appeal, both the sides are willing to dispose of the matter.
Yes, my lord.
My lord, a hearing is needed, my lord.
If my lord, lower court
without hearing the parties, no court will dispose of any matter. 3751. Yes.
Court record has already.
Yes, 3751 is application for stay. At this juncture, it is not required to be heard. Even next হচ্ছে দেখুন can 9535 of 2012. 9535 of 2012.
Already disposed of on 17/7/2019.
17/7/2019.
By the Honorable Justice S.K. Prasad.
17/7/2019. Substantial questions of law. 3 substantial questions of law have been framed.
No, man, that is there.
The substantial questions of it will be in the paper book at the end of the paper book. Wide order dated 15/5/2009. An application for stay has entered appearance and the appeal be treated as ready as regards service. In the front,
At that time, that
and the other defendants are
procedure was
preferred
not
in
done.
spite of passing of dictation in the trial. We dispense in our view, during the pendency of appeal, the parties should be directed to maintain status quo. The parties should be directed to maintain status quo as regards nature, character, and possession of the property as on this day. The parties are also restrained from transferring, alienating, or encumbering the property except by taking leave from the court. Stay application has also been disposed of. Thereafter, can 9535 dated 19/7/2019. That this appeal is ready for hearing. Names of applicants be substituted in the cause title of the memorandum of appeal in place of deceased sole appellant. The sole appellant had expired. Memorandum of appeal টা দেখি memorandum of appeal মেমোটা দেখুন তো ইনকর্পোরেট হয়েছে কিনা নামগুলো হ্যাঁ হ্যাঁ এইটা মেমো ঠিক আছে হ্যাঁ এবার ওই তো দেখুন incorporated. The names of the substituted appellants are also there. So no application is pending. তাহলে এটা order করতে হবে নিন on perusal of the order book, it transpires that by order dated 15/5/2009, an honorable division bench of this court at the time of admission of the appeal has framed three substantial questions of law and the said bench has also directed the parties to maintain status quo as regards nature, character, and possession of the property, and the parties have also been restrained from transferring, alienating, or encumbering the property except by taking leave from the court. Full stop. As regards to paragraph, as regards to can 9535 of 2012, the said application has been disposed of on 19/7/2019. Full stop. In paragraph, in such circumstance, the said appeal is otherwise ready for hearing. Full stop. Paragraph. On consent of both sides, let the matter appear on
27th
27th. Why 27th?
or 21st, next week, 21st
Let the matter appear
or 20th, any which one. Next week.
next week. 17th.
17th.
18th,
17, 18.
19th. Let the matter appear on 19th. আপনার পেপার বুক তো আছে।
Grateful, my lord.
Next. Not today.
At the time for the appellant, Mr. Harzan Banerjee is appearing in this matter. He was admitted in nursing home. He has been released yesterday, but he needs some time to appear before this court, madam.
Are you aware how many applications are
My lord.
actually pending?
My lord.
Lordship, I'm led by Mr. Shomojit Mujumdar in this matter. He has not come to court today, praying for a day's accommodation.
Both of you are not aware.
Your Lordship, no.
When can Mr. Banerjee apprise the court?
After 17, my lord.
Nin. 104. Learned advocate representing the appellant seeks accommodation for a week on the ground of his senior. Full stop. Paragraph. The learned advocate representing the respondents also seek an accommodation for this day. Full stop. Consider the submission of learned counsels. Let the matter appear on 19th.
My
Let the matter appear on 19th. Next. How many applications are pending? Learned counsel? How many applications are actually pending? Hmm?
One for restoration of the application.
Restoration of the?
Restoration of recalling order. Recalling order of. And
Restoration application pending. That is being can number
somebody is not applied for.
and the other one?
Other
How many days delay?
actually, there are 512 days delay, but in application, 168, only one year has not been explained.
1 year has been bypassed.
Yes, on a order passed on
Hmm.
11 July 2024, and he has stated that
Learned counsel, are you ready with the hearing?
no,
What do you intend?
after application is pushed up, then
Hearing means hearing of the application.
hearing of the application.
Are you ready?
Appellant is not there.
Are you ready?
Yes.
You are ready. You do not intend to file any affidavit in opposition.
Hear from the government that they are misleading the court.
105. none is representing the appellants. None is representing the appellants, while the respondents are being represented. Full stop. In such circumstance, the matter cannot be proceeded. Let the matter appear on twentieth of August. Next.
106. My lord, I am praying for not today only. Mr. Gorun Boron saw appearing, he is engaged another.
Not today, next. Not today, next.
107. My lord, I am for the appellant, my lord. There is no application is pending, my lord.
In which one?
107.
Oh, you are appearing both 106 and
No, my lord.
107.
One clerk requested me 106, my lord.
So in 107, you are the advocate on record.
No, my lord. Mr. Prashanth Bihari Mahato is advocate on record.
No application pending.
No, my lord.
Yes, there is no application. So it is ready for hearing. Otherwise, it is ready for hearing.
Yes, ma'am.
For the appellant.
Appellants. Yes.
দেখি ওই 107টা দিন দেখি আচ্ছা যেগুলো ওই যে একটা কোনো অ্যাপ্লিকেশন পেন্ডিং না যেটা বললাম ওই যে মেইনটেইন স্ট্যাটাস কোড বললাম না ওটা কিন্তু উইল অ্যাপিয়ার আন্ডার দ্য হেডিং হিয়ারিং। হ্যাঁ ওটা লিখে দিন এত তারিখ আন্ডার দ্য হেডিং হিয়ারিং। হ্যাঁ 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 ভালো আগে বার করুন করে ওই তারিখ এত আন্ডার দ্য হেডিং হিয়ারিং। ওই এসে এসে যেগুলো হিয়ারিং আসছে সেগুলো টপে আসবে, ঠিক আছে? তারপর যা সিও এসে যা না দেখুন ওখানে কোনো ক্যান আছে কিনা। এসএ 461 দেখছেন তো? এসএ 461 অফ 2016 কোনো অ্যাপ্লিকেশন আছে ক্যান? 23 ওল্ড নাম্বার বলুন, ওল্ড নাম্বার। এটা নয়, এটাই তো এসএ 461। এটা কত? 3 ক্যান নাম্বার 385 of 2017. Status code position will be maintained to the disposal of this application. The status quo as regards possession of the parties in the suit property will be maintained till the disposal of this application. It has not been disposed of. So there is order of status quo. That will be made absolute till the disposal of the appeal. But apart from this, আর কোনো কেন আছে বলুন?
3268.
আচ্ছা দেখি 3268 দেখি। under order 39 rule 2A of the code of civil procedure
Filed by
filed by you. against the defendant, no, filed by the respondents against the defendants appellants for deliberate violation of the order of Honorable High Court.
That was disposal.
That has also been disposed of. Wide order.
Order sheet is not there. 24 September
Yes,
2024.
No, 26th November 2019.
Yes.
We therefore do not find any substance in the instant application.
Hmm.
The application being CAN 3268 of 2019 is devoid of merit. The same is hereby dismissed. It was disposed of হয়ে গেছে. Any other CAN application pending?
And 2314.
Of 2314. CAN 2314 dismissed as not pressed. And any other application pending? গেল কোথায় হারিয়ে স্ট্যাটাস কো বললো যে till the disposal of the application. আচ্ছা ঠিক আছে আরেকটা যেটা ডিভয়েড অফ মেরিট একটা বললাম না সেটা হচ্ছে এই যে এটা হচ্ছে 3268. হ্যাঁ ঠিক আছে তাহলে আর কোনো অ্যাপ্লিকেশন আছে আর কোনো অ্যাপ্লিকেশন নেই so otherwise it is ready for hearing, learned counsel.
Yes, ma'am.
Here for the appellant or appellants. It can be fixed for hearing.
Yes,
When?
10 days time.
Learned advocate, you are the advocate on record?
No, my
Then learned advocate representing the appellants submits that there is no application pending full stop. He further submits that the present appeal is otherwise ready for hearing. Full stop. Paragraph. None is there to represent the respondents. Full stop. Paragraph. On perusal of the record, it transpires that an application being CAN 385 of 2017 seeking stay of the impugned judgment has been dealt with by a division bench of this honorable court and through order and wide order dated 28/3/2017, it has been directed order dated 28/3/2017, the respondents plaintiffs have been restrained from putting the impugned decree into execution till the disposal of the application. Full stop. Full stop. Paragraph. Otherwise, apart from this application being made absolute, there is no other application pending in the present appeal. Full stop. Otherwise, the present appeal is ready for hearing. Full stop. At this stage, paragraph, at this stage, the learned advocate representing the appellants seeks an accommodation for 10 days. When can it be fixed? Why 10 days, learned counsel?
25th.
No.
25.
18.
20. Make it.
1 week is more than enough. You are getting 1 weekend.
25.
Let the matter appear on 24th of August.
25th. Tuesday.
25th of August. Under the heading hearing. Let it appear under the heading hearing.
Yes.
देखे दिन next with 109, 110. Not today. Next.
Lord, I am appealing for the respondent number 1, my lord.
Respondent number 1.
Yes, sir. My lord,
Civil
Mr.
division.
My lord, Mr. Sukando Das is appearing for petitioner, my lord. I am praying only one day time. His clerk requested me to take
Seeking accommodation for this day only.
Yes.
Not today. Next. Learned counsels, let this court be clear. For 1 or 2 days, this type of orders will be passed. Thereafter,
well, I am ready with the matter.
Necessary orders will be passed. Next.
My lordship, I'm appearing on behalf of the petitioner. I'm being led by Mr. Shombhavu Mukherjee. My lordship, we are yet to receive some instruction from our client. If your lordship feel kind enough to
That is between the client and yourself, not with the court. Court is not at all interested to hear that.
If your lordship feel kind enough to accommodate the matter after 2 weeks.
What?
2 weeks, my lord.
For this day, not today. Next.
Lordship, I'm appealing for the petitioner, bring 1 week accommodation.
I'm for the opposite parties.
Why?
Mr. Pinaki Chakraborty is appearing. His mother is not well. Due to that reason, he is coming frequently to the court. For that reason, I'm praying.
For that reason, he
is not in a position to come regular basis, Lordship. 1 week time, Lordship. Fix any date, Lordship, coming week.
Your submissions are contradictory. You are saying that he is unwell, and on the other
Mother
hand,
is unable. Because of that reason, he is not coming regular basis. Due to
when
that
can it be fixed? When can it be fixed?
19th, Lordship.
Also, kindly first week of September.
No, 19th, Lordship. Fix it on 19th, Lordship. 19th August, Lordship.
August, Lordship, there's some other matters are there. So let's say first week of September, there is no urgency in this matter.
No, 19th, Lordship, fix it 19th, Lordship. As per his instruction, I am paying that.
Let it be fixed on 24th.
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 Lordship. Yes.
Nin. If on that day.
On that day, he will not come. I will appear on behalf of the
Yes.
Lordship and I will
Yes.
plead the matter, Lordship.
Yes, there won't be any
Yes, yes,
adjournment.
yes.
Lord Advocate representing the 113, representing the petitioners seeks an accommodation for 10 days, no, for a fortnight, on the ground of the senior. Full stop. Paragraph, the learned counsel representing the opposite parties, we are representing all.
One of them expired, they have filed substitution.
There are four
Four
applications.
can, Lordship. One can is substitution.
4 applications.
Yes,
Can
yes.
1 of 23.
One is substitution. Thereafter,
Substitution.
yes,
No,
and
one
thereafter,
is restoration.
sorry, one is restoration. Thereafter, Lordship, the one of the defendant opposite party won, that is died. Before that, restoration application was filed. Due to that reason, abatement application was filed and substitution with section 5 application that has been filed. There are 4 applications.
Restoration. Substitution.
Substitution in connection with the section 5, that is another application.
So you have paid for substitution after how many days? Beyond 150.
2020 expired.
Beyond 150 days.
The 2020 expired, filed in the 2023.
Lordship, after getting the information, I
25.
filed it, Lordship. Thereafter, the abatement application filed because the restoration application filed, his name was there. Dependent.
Consider the learned counsel representing the opposite parties seeks an accommodation. Seeks an accommodation for fortnight. Full stop. দুজনের একই petitioner and opposite parties seeks an accommodation for fortnight. Paragraph, consider the submission of learned counsels, let the matter appear on 24th.
Look, I am not praying for any accommodation.
Oh, you are not praying for accommodation?
I am ready. I am ready.
তাহলে শুধুমাত্র learned counsel representing the petitioners seeks an accommodation for fortnight. Consider the submission of learned counsel. Consider the submission of learned counsels. ঠিক আছে? Counsel করে দিন, counsel for the petitioner. ঠিক আছে? Let the matter appear on 24th.
24th August.
24th August.
Yes. Grateful, Lordship.
There won't be any further
No,
accommodation.
no. I will not. I will plead, Lordship. On that day, if he will not come, I will.
As far as I can remember, you had stated this matter only one day. That is about a year ago.
After
About a
this
year ago.
initial, Lordship, the initially died, subsequently dismissed for default, whether restoration application is maintained against the dead person.
After dismissal, this person has expired.
Initially died, dead.
During the pendency of the revision, the person expired.
Expired.
One of the petitioners.
One of the opposite party.
One of the opposite parties expired.
Expired.
After getting
Choose not to substitute. Subsequently dismissed for default. Now restoration against the dead person, whether maintainable.
Lordship, after getting the information, the restoration substitution application was filed. After getting the information, before that, restoration application was filed, and thereafter, abatement application was filed.
Come prepared on that day. Come prepared on that day. Next.
I'm for the respondent, my lord. This matter came up before lordship on my instance. Because the appellant, this is a suit for eviction under Premises Tenancy Act, New Act. The appellant lost in both the court. Judgment of affirmation.
You are the landlord.
I'm the landlord. Now, my lord, since they had obtained a interim order, they had not taken steps for disposal of the appeal. Now, in the meantime, in the year 2023, the sole appellant died. I don't know whether any substitution application at all filed or not. They are enjoying an interim.
In which year?
2023.
2023. On application is pending. 114, item number 114.
114.
One application is pending, being number CAN 2 of 2024.
Oh, no copy has been served upon.
SAT 434.
Yes. No, there are defects, I think, well, because there's order of Lojima court regarding the defects. I don't know whether the defects has been cured or not. আপনার মাপে ফাইল এসে গেছে। বড় ফাইল হবে না, এলসিআর নেই। এলসিআর নেই। Yes, Your file
It is not traceable at this present juncture.
Yes, Your Honor, I can understand.
I can note to the third.
Macho. Macho.
One hundred 117, 118. Okay. 119, 120.
For the respondent, my lord, late Mr. Shivaprasad Ghosh is not coming due to her illness. Kindly one day accommodation.
This is an application for stay, my lord. Your lordship. Honor. Yes, my lord.
SMA 3 of 2024.
Yes. And two.
You are ready with the hearing? You are ready for hearing?
Yes, my ready for my application for stay is here, my lord, only for application. Your lordship, at that time, my lord, on 6/8/2024, Honorable Justice Modhuresh Kotal and Honorable Justice
And myself.
yeah, myself admit the appeal, my lord.
Acha.
At that time, there are no stay, my lord. On that ground, I filed this application, my lord.
They are seeking accommodation. What is your prayer?
Only
Bit
accommodation.
louder.
Due to my senior counsel illness.
Illness. He or she. She will be cured by today.
No.
So
Next week. No.
what do you intend? What is your prayer?
Next week, my lord.
Huh?
Next week.
Next week.
Any day. Next week, any day.
SMA item number 120 SMA 3 of 2024. ওনার নামটা নিয়ে নেবেন learned advocate representing the দেখি ফাইলটা দেখি What is the matter about?
Matter about, my lord?
I'm not going into the hearing, but only prima facie.
Just a minute, my lord. Prima facie appears that, my lord, that my point is, my lord, expertise degree was passed, execution case was.
So there is a report dated 9th of April 2026.
Yes.
Stating that the department has not received
Yes.
the Tolowana cost of rupees
No, no,
4.25
yes.
and written up notice forms for effecting service of notice of appeal upon the respondent numbers 1 to 6. You are representing whom, learned counsel? You are representing whom?
All the respondents. my lord.
All the respondents. You are aware of the fact that you are representing all the respondents.
Change brief, my lord.
Whether you are representing all the respondents.
All the respondents. All the respondents.
All the respondents. Okay. Rather than an order for on examination, there is a further report, learned counsel. There is a further report on examination of the trial court records. It has been found that plaintiff's exhibits.
Yes. Special manager cost, I have already.
Plaintiff's exhibits list is not in proper form.
Yes.
Who was the plaintiff?
Plaintiff,
You were the plaintiff.
Plaintiff, they are the plaintiff.
They were the plaintiffs. Not in proper form, and exhibited documents are not marked with exhibit number. Files two cover files are
ফাইল করছি না দেখে নে না দেয়নি
অ্যাসিস্ট্যান্ট রেজিস্ট্রার 9 এই যে তো ওইখানে কেন সই করেছে এইখানে তো সইয়ের জায়গা তো অ্যাসিস্ট্যান্ট রেজিস্ট্রার সইয়ের জায়গাটা তো ওইখানটা ওইখানে কেন করবে জায়গা থাকছে যেখানে অ্যাপ্রোপ্রিয়েট জায়গা সেখানে সই করবে তো এখানে তো করবে so they are representing all the respondents. Have you filed affidavit in opposition? There was a direction to file affidavit in opposition.
Opposition and reply. Opposition reply, yeah.
Huh?
This is our reply, my lord. Opposition already filed, my reply.
Learned counsel, once you represent any person, you will have to be aware with the fact. Otherwise, do not represent.
হ্যাঁ
120
ওখানে কয় ফাইল করে রাখতো
Can 2 of 2024.
22nd May 2025. Opposition filed, my lord.
22nd May
2025. Reply, my this is my reply, my lord. Reply,
Yeah, reply also.
11 June 2005.
এখানে তো কোনোটাই নেই দেখছি affidavit of service. Neither the affidavit in opposition nor the affidavit in reply.
Reply, my lord, is here, my lord. Oh,
acha, you have not yet filed.
no, not his file.
Not yet filed. The affidavit in opposition is not here. 1 minute.
The time of hearing it will be filed, my lord. That is possible.
Have you served copy upon them?
Yes, yes.
acha, affidavit in opposition, লিখুন affidavit in opposition in respect of CAN 2 of 2024. No, he also cannot apprise whether it has been filed or not.
Yeah.
On perusal of the order book, it transpires that void order dated 18th of February 2025. A coordinate bench of this honorable court had directed to file affidavit in opposition and within 3 weeks, and thereafter affidavit in reply within 2 weeks therefrom. On perusal of the record, the affidavit full stop. The learned advocate representing the opposite parties cannot apprise the court whether affidavit in opposition has been filed or not. Full stop. Full stop. He further submits that his learned senior is not well, as such seeks an accommodation for this week. For this week. As such, he seeks an accommodation for this week. Let the matter appear on 17th, Monday.
18th. No, 17th, 19th.
Let the matter appear on 19th of August. ঢাকা যাবে না
আচ্ছা
না 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 ও চেম্বারে কি ভুল হয়েছে কবে কোথায় কবেকার কালকে তাহলে আমি সই করেছিলাম তো তাহলে তো ওইটা লাগবে ওইটা লাগবে না 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 খুললে হবে না ওটা লাগবে Yes, Learned Counsel.
Already 4:30.
Already 4:30.
124. Taken up day after tomorrow. 124. Tomorrow I am not here.
Let it appear. Let it appear tomorrow. Let there be someone. Let there be someone to